My lord. Let to move this tomorrow, my lord. Great. Lordship. Application.
Give the slip.
Lordship, may I permit you to mention one matter, Lordship? Lordship, it's an inclusion in the leads, Lordship.
Give the slip, man.
Yes, Lordship.
Call the yes.
One minute, I appear for the petitioner. So this matter
And for the
heard
municipality lordship.
by the Honorable Single Bench previously, and it was not disposed of without not granting any relief. Appeal was preferred. The Honorable Appellate Bench has directed the hearing of the matter, and this shall be getting a chance to file an affidavit. Grievance is very short, my lord. The petitioner is a widow, aged more than 70 years of age. In front of her ground floor flat, first floor flat window, just below the window, low sign board with a permanent structure has been constructed and not fixed. So that first is that is not permitted because it becomes a part of the building as per the definition of building. Municipality has served a notice against them, but it has not been removed. And thirdly, it is just not a stepping stone for getting into my property. I am a single lady staying, so that is a safety problem also. This is the problem I am facing.
Lord,
I want to file an affidavit. Kindly,
my lord, I beg to appear on behalf of the private respondent, my lord.
Who's for the municipality?
Lord, so I am for the municipality, lord.
File your affidavit.
My lord, liberty was also granted to me, my lord, to file affidavit
File
in
your affidavit.
happening for the state. This is the order of the Honorable.
This court-wide order dated 4/11/2024 dismissed the present writ petition. Full stop. The petitioner had approached the Honorable Division Bench in FMA number 13 of 2025. Full stop. The Honorable Court-wide order dated 9/1/2025 was pleased to set aside the order dated 4/11/2024 and remanded the matter with a direction to examine the same after affording an opportunity of hearing to the parties. Full stop. Learned counsel for the private respondent as well as the respondent as well as municipality seeks and is granted 4 weeks time.
Lords.
4 weeks time to file
Lords,
affidavit.
4 weeks after vacation.
4 weeks after vacation.
4 weeks after vacation will be 2 days. 4 weeks.
Lords,
They could have used prepared
4 weeks affidavit in opposition. How much time?
1 week.
1 week reply thereafter.
Lord, liberty may also be granted, my lord, to file wakalat now, my lord.
Liberty level.
File your what liberty? You have the liberty to file wakalatam.
You should take leave to file it by course of this day.
After 5.
Lord, within a week, within my lord, this week, my lord.
24/6.
Develop.
I'm good. Develop, like.
Obligement.
Item number 2, petitioner is not willing to place this application.
Take down.
This is a written letter, Lordship, by the petitioner.
My lord, item number 1 is over, my lord.
Yes, petitioner seeks to withdraw the present writ petition. He hands over a copy of the instruction which he has received from
Yes.
his client. Full stop. The same is taken on record. The present writ petition is dismissed for non-prosecution.
Grateful, Lordship.
Yes.
My lord, item number 3, the petitioner wants to withdraw this matter, my lord.
You have an instruction?
Yes, my lord. I have the instruction.
We have the statement by Mr. Vimal Kumar Shai, my lord.
Give the instruction.
State, my lord, I am appearing on behalf of the state.
Lord, I am
Give your
for the-
appearance. Same order.
My lord, I am for the KMC,
Give your
led
appearance.
by Mr.
Give your-
Vimal Kumar Shai.
Give your appearance, madam.
Grateful, my lord.
Develop.
No, that's item number 4. I appear on behalf of the petitioner, Mr. Shuddhasatya Banerjee, is leading me in this matter. He had proffered his submissions on the last day today. My learned
Sir,
senior proposed
I have my lord, submitted, my lord, and my lord was pleased to direct me, my lord, to take out with the written notes on that score. And the judgments, my lord, to be relied upon. No, judgments I am handing over, my lord, it will be handed over after half an hour because I dictated it, but I could not check it up whether there is any typographical error or not. Kindly, I'm handing it over, my lord, within half an hour, my lord, I will hand it over. The
Yes.
judgments relied upon, my lord, I have given, my lord. And I have justified, my lord, in my note how it is to be relied upon.
Your Lordship will just kindly request him to hand over a copy to us.
Copy, my lord, I can hand over, my lord, citations, not the written notes.
Yes.
We should deal with all this.
My lord, in short, your lordship, the points to be, my lord, considered. First thing, my lord, the writ petition as it is not maintainable. For the sole reason, my lord, your lordship will find the deity has become the petitioner. My lord knows in respect of an Arpanama deity being a perpetual minor, it itself cannot maintain a writ petition, my lord, unless and until it is represented by all Sevites. Now that if my lord kindly considers the writ petition, my lord will find that only deity and another person has been shown to be, my lord, the writ petitioner. From that score, my lord, it is not maintainable. The second aspect is, my lord, the writ petition has been affirmed by one constituted attorney appointed by other constituted attorneys. And on that score also, my lord, he is incompetent to maintain this writ petition.
Yes.
If my lord kindly considers page 101, my lord will find my contentions. Kindly see, my lord, the letters at page 101. Repeated letters are there, how it has been described.
Yes.
My lord has got it, man. Kindly see, my lord, at the top. From Binod Kumar Baid, constituted attorney of Vikas Chandra Sinha, Anindya Sinha, Sebayats to the deity Sri Janardhan Jew.
Yes.
So admitted position, my lord, out of 3 Sebayats. He claims himself to be the constituted attorney of 2 persons.
Yes.
Keeping aside, my lord, the third one. Now, kindly come to the signature at the bottom. But at every page, my lord will find. What is the seal? On behalf of Sebayats to the deity of Sri Janardhan Jew. On that score also, alone, my lord will kindly dismiss this writ petition. It's a wrong statement altogether. He is not the constituted attorney of all the Sebayats. The question is, my lord, that whether he can be appointed as a constituted attorney of the Sebayats. My lord, in an Arpanama under Hindu law, the Sebayats are only, my lord, at the base, my lord, manager to manage the affairs, my lord, on behalf of the minor deity. Not as constituted attorney or, my lord, as the trustee under the Indian Trust Act.
Yes.
They are duty bound, my lord, to do strictly in terms of what was stated in the Arpanama, terms and conditions.
Yes.
Nothing beyond that. If the Arpanama doesn't permit them, they cannot, the Sebayats cannot, my lord, appoint any constituted attorney. Because, my lord, knows, my lord, the legal maxim, my lord, delegatus non potest delegare.
Yes.
Next aspect you will also kindly see in the writ petition now. Kindly
So
come
these are
to-
your 2 arguments for
Yes,
non-maintainability.
not maintainability. Next, you will also kindly come to paragraph, my lord, 6 and 7.
of the writ.
from the writ petition.
Yes.
The petitioner states that the said estate has now been under actual financial distress and the estate has a very meager and nominal income. There are huge statutory expenses being incurred by the estates. Since last 15 years, no rent or other income is fetched from the premises. The said premises pays no contribution to the Seva Puja of the petitioner, and to achieve the objective of the trust, with every passing day of the situation is likely to be worsened, and the Seva Pujas would not be in a position to fulfill the obligations imposed under the deed of dedication because of these ever increasing liabilities of the estates.
Yes.
Next, my lord, that a portion of the said premises are occupied by unauthorized occupants and trespassers. The petitioner states that the said property is facing impending threat of being lost forever. The trust has no money even to do any litigation against the occupants. This is the contention and this is the justification, my lord, for the purpose of development of G+11 story construction through a developer. But we do not know what is the development agreement. That has not been placed before, my lord.
Yes.
We do not know what is the terms and conditions or what are the powers has been delegated to the alleged constituted attorney, Mr. Baid.
So why do you need that?
Yes,
Why do you need that?
because my lord will have to see that whether a person in the garb of constituted attorney of the developer is acting on behalf of the developer or not. There, my lord will find whether there is any sort of, my lord, practice, if I may say so, my lord, malpractice. I don't use to any harsh word, but this is the position. Now, your lordship will kindly come to the, my lord, deed of Orponnama, my lord. It's a Bengali document, my lord, and translated copy, my lord will find from the translated copy. I'm submitting the pith and substance. The pith and substance of the,
Which page?
my lord, it starts from page 26, possibly, my lord.
Yes.
No. It starts from page 22.
Page 20 actually.
Page 20, my lord, the other pages are there.
Yes. Where's
The
the
signatures and all these things.
Yes.
They are also, I'll have to make some submissions on that score. Now, from this page, my lord will find the description has been given and what has been stated categorically. Since they have taken a plea that even the Seva Puja cannot be done, kindly see, my lord, what is written over here. And I am reading, my lord, the running page 7 of the document. Here, what has been written, well, I am just telling in, my lord, English, because it's a Bengali document, that if there is any shortfall to meet the expenses of the daily expenses of the deity, the Sevais will do of their own, either of their own or by way of temporary loan to the deity for the purpose of mitigating the hardships. This is most important thing, my lord, because the plea is that they are unable to do that. Kindly see to it whether these two tallies, the contentions raised in the writ petition, tallies with the terms and conditions which are there during the time of settlement of Orponnama.
So that is not how it reads.
Yes,
Before transferring the said DT, we have.
yes, it was agreed. That's why it has been transcribed, my lord, in writing.
Yes. out of our own personal fund shall do whatever
Yes.
renovation, alteration, expansion of the said house,
So, my
or
lord,
construction of any new building
yes,
and
on that
mandir.
basis, the settlers have settled, and the settlers are the Sebais.
So that's all right, sir, but your contention is slightly different from what it is written here.
No. Kindly see, my lord, I do
May
not
be
know what has
known
been
that at the time of renovation, alteration, expenses, the Shebayats shall arrange for the Seva Puja. So it is during that period they are saying that they will be.
No, your lordship, kindly see.
I'm only reading from the document.
Yes. Next, another thing your lordship will kindly see. Kindly now, my lord, come to, my lord, because another condition is, my lord, that the rents they are not able to collect.
Yes.
They are not able to collect. Now, you will also kindly come to page 9, running page 9, page 36, Bengali document, page 36. My lord, the first contention which why I was saying. আরো প্রকাশ থাকে যে সম্পত্তির আয় হইতে উক্ত সম্পত্তির খাজনা ট্যাক্স ইত্যাদি দিবার খরচ অথবা দেব সেবার নিত্য নৈমিত্তিক খরচ নির্বাহে সংকুলান না হইলে, it means, my lord, if it cannot be done to maintain the daily expenses, যে পরিমাণ অর্থের অনটন হইবে, the shortfall will be made good by the Sebais according to their proportion. নিজ হিস্সা অনুযায়ী ব্যক্তিগত অর্থ হইতে বহন করিবেন অথবা বিগ্রহকে সামগ্রিক ধার দেবেন. So that was I was contending. I was reading another portion, my lord. The other portion is there. So what I have contended is exactly the same.
All right.
Next, my lord. Next, you will also kindly come to, it starts from page 10. What is it?
17, 18, 20. Yes.
Next, my lord, at page 10, page 38. Running page 38, my lord, internal page 10 of the Bengali document.
Yes.
It speaks of, my lord, some property which under the landlords called as Chandina property. Chandina property means, my lord, some non-agricultural land and non-agricultural tenants are there.
Yes.
Some sort of, my lord, shop rooms and all other things are there. They are occupant. They gives, my lord, rent per month. They gives rent per month. Now the condition and the provision in this Orponnama is they will realize.
Yes.
What would happen in the event they cannot realize or there is any default? At page 11, it has stated. In the event, they
But
tenants.
how is this relevant for the purposes of
Because of
such?
this reason, I am showing your lordship will kindly consider when a Devotur property by virtue and of Orponnama is sought to be done. But this is the settled proposition everywhere. Because in these cases, what is done, well, right
No,
from
that
19
argument I appreciate.
Yes,
Your argument regarding the deity,
deity.
that
No, I'm
argument,
coming. Why I am saying But in this case, in that event, if it is that so that the property has to be sold or a long-term lease has to be given, then a permission from the competent civil court has to be obtained because of the sole reason that the deity is a minor. Deity is a minor.
No, but that issue is not here.
Yes,
That issue is not here.
that
The
issue is
which
not here. Now, question is whether whether a deed of Arponnama can subsequently be rectified by some other signatories who were not the original settlers. That I'll come to that. Why I am saying this for this present, that the justification sought to be made as shown or established in the writ petition is that financial crunch. It is not there. The justification that they are not paying the rents, it's not justified. It would amply prove that the Sebayes have miserably failed to discharge their obligatory duties which was given to them by virtue of this deed of Arponnama. Now, if that is so, who will manage the property? It's not a trust property, my lord. That in cases of a trust, my lord, that the property, the trust itself may be dissolved.
Yes.
And Arponnama, a Devottor estate cannot be dissolved.
Yes.
In the event, my lord, the Sebayes are unable or no legal heirs. According to this, my lord, only the male heirs will be there. So, my lord, if no male heirs is available, what would happen? It is, my lord, it is the duty because ultimately, my lord, it's my lord, I'm referring of a judgment, my lord, at pre-independent stage. There, my lord, our honorable court as well as my the Privy Council has held that in that case, what would happen? It has been stated, my lord, that the crown will take care of it. Now that, my lord, it's the constitution. Constitution will take care of it. Because, my lord, under the constitution, my lord, the statutory laws are that the deity is riot under the West Bengal State Acquisition Act, under the West Bengal Land Reforms Act. That is also held. So in all such cases, my lord, even if any development is required to be made for the interest of deity, for the sake of argument, I am accepting it. In that event also, my lord, an application has to be made before the landed district judge. And what they are trying to do by virtue of a rectified deed, which was the original Arponnama was of 1964, and the, my lord, alleged deed of rectification was made in the year 1976. Now I'll take that, my lord. Here there is a provision, my lord, they should take the legal proceeding. But admittedly, my lord, they have stated for last 15 years, nothing could be required from the tenants. No proceeding has ever been initiated. My lord being the guardian, my lord being the guardian of the all such situation in a court of law, and the representative, my lord, in its constitutional capacity, my lord will look whether the Devottor property is being properly utilized or not. It's a bounden duty upon all citizens also, be it private Devottor, be it public Devottor. Now, your lordship will kindly come to. My lord will kindly allow me 2 minutes. One matter is there for withdrawal at circuit bench. I say yesterday I was there. I have come here and only 2-3 minutes, my lord.
You're on your legs, Mr.
My lord, your lordship, kindly excuse me with folded hand. I am requesting, my lord, kindly for 2-3 minutes. Because, my lord, initially there was a direction, my lord, subsequently it was for. Peter. But the court has said, my lord, it is item number 1 only for withdrawal.
You're already on your legs, Mr.
I do, my lord. That's why I am seeking my lord's kind permission. For 5 minutes, 10 minutes, or after half an hour,
What
according.
will this court do? Wait for you to come back?
No. My lord will continue. I kindly fix a date, my lord, time, my lord. Today itself, my lord, after half an hour. You'll also kindly excuse me. I'm really, my lord.
Your junior can take over. He can make submissions.
So, my lord, let him take, my lord, let him read this. এখানে পড় আমার করা আছে, এটা কারেকশন করা হয়নি এখন। আরে বাবা, এই যে রেকটিফিকেশন মানে for 2-3 minutes.
My written notes, my lord. Page 11, my lord.
Where are the written notes? Not
I-
yet handed over. Give a copy.
হ্যাঁ জমা করেছি তোমার ও করছো তখন করেছি না যাই দেখুন তো দিয়েছি এখানে দিয়েছে
नहीं दिया नहीं
এই এটা But 20, my lord, page 11, my lord, 20. Page 11. My lord, got it.
Yes.
A deed of rectification of Arponnama was executed on 13/8/1976, wherefrom it would appear that the said deed of rectification of Arponnama was signed by one Atish Chandra Sinha, one Virendra Chandra Sinha, and one Abha Sinha as constituted attorney of Atish Chandra Sinha. Such execution is not valid in law, impermissible in law. A Sevaiyat cannot appoint any constituted attorney on his behalf. At the best, he can appoint an agent. From the said rectification of Arponnama, it would appear that the original Arponnama does not contain any provision for lease for any period oblique long lease and the name of the bank. হয়ে গেল তো? এখান থেকে পড়।
Sorry, my
হয়ে গেল?
by now it has been over. But overnight I have to come early. Now you'll also kindly take page 83. Page 83 of the report.
Yes.
Page 83 is my lord, rectified deed of Arponnama.
Yes.
Kindly come to page 89. Who are the signatories? Kindly see, my lord, the first signature is Atish Chandra Sinha. My lord has got it, my lord.
Yes.
Next, my lord, Abha Sinha
Yes.
as constituted attorney of Atish Chandra Sinha. Then, my lord, Bindavan Kumar Sinha. Now, in the first deed, my lord will find the first deed was executed, my lord, by Bindavan Chandra Sinha, Atish Chandra Sinha, Adhish Sinha, my lord. They were there and somebody was as legatee, as representative, my lord, put their signature.
Yes.
Now, the question would be, my lord, as per Hindu law, as per the Arponnama, my lord, when a property is settled, my lord, in favor of a deity, the settlers, my lord, are divested of any sort of right. They do not have any right to make any correction in the Arponnama, my lord, unless and until the original Arponnama provides that. The original Arponnama, my lord, doesn't provide any such provision. In that view of the matter, my lord, the rectified deed of Arponnama, but is void of an issue. It has no value in the eye of law.
Yes.
And that too, my lord, you will also kindly see again, my lord, delegate as non-potest delegate. The Abha Sinha, a female member,
Yes.
appears to be, my lord, the constituted attorney.
Yes.
But a delegate cannot further delegate his right in any event of the matter. These are the position, and my lord will find from the record that this honorable court, my lord, directed why it was not done. A report submitted on 25th of January 2025 before this honorable court in the form of an affidavit. There, my lord, the enclosure will speak that since both the deed of Arponnama deviates,
Yes.
my lord, the plan was not sanctioned. Plan was not sanctioned. Now, the other thing is, my lord, that they have admitted in their writ petition that since the original deed of Arponnama did not provide for any long-term lease,
Yes.
or that how and where the money is to be kept or deposited, this rectification is required. With another thing that the deity will be shifted. My deity will be shifted. I have found some cases where, my lord, in some situations, my lord, it could be. It could be, my lord, for temporarily shifted, not permanently.
Yes.
Because the position is, my lord, what is dedicated, it's not a mere chatal. This is the language has been used by this honorable court.
Yes.
In such view of the matter, for the purpose of development, some building will be erected thereupon and the deity will be shifted elsewhere. But this is not permissible in law. This is not in the true spirit of the deed of Arponnama.
Yes.
Original deed of Orphanama. You will also kindly see the rectified deed of Orphanama is not at all acceptable. In such view of the matter, my lord, this building plan was not sanctioned. Now that my lord, my learned friend's client, my lord, have relied upon 3 judgments from time to time. One is of 2009, another is of 2019, and a division bench judgment of 2014, my lord, presided over by my lord Justice Joymallo Bagchi, and where my lord was one of the honorable
Yes.
judges. My lord, with due respect, I am submitting, my lord, those judgments, my lord, nowhere, my lord, particularly by the division bench, did not consider the earlier division bench order, my lord, on this issue. In 2016 itself, my lord, the division bench of our honorable court, I'll place, my lord, I have cited the judgments. The deity is a perpetual minor. For the purpose of dealing with the properties or development, my lord, civil court's permission is required.
Yes.
This finding is there in that division bench judgment, which was not considered. To that extent, my lord, the judgment delivered by my lord and my lord Justice Bagchi, my lord, with due respect, my lord, is par inferior. And that too, my lord, that judgment cannot be cited as a precedent because the facts are to some extent different. My lords were pleased to deal with a trust property.
Yes.
And my lord knows the doctrine of precedent. If there is a difference in single set of facts, it may make a world of difference. This is the settled proposition. These are in my humble submission. These are the humble submission, my lord, on my part. But after correcting these written notes, my lord, I'll submit it. Huh? Cannot my lord, it requires, my lord, a little bit of correction, my lord, if my lord permits me, my lord, to check, because my lord, after giving dictation, my lord, I was there before the circuit bench. আমি বলে গেলাম তো তুই শুনলি
No, he was just reading from it.
anyway my lord, half an hour or within 1 hour in course of today it will be handed over to my lord. Now my
Judgments.
হ্যাঁ yes judgment গুলো আমি তো কপি দিয়ে দিলাম যে কোন কোন সাইট করছি. Yes my lord, judgment I have, my lord, handed
Yes,
over the
yes.
copy, my lord.
Yes.
In my written notes, my lord, I have given, my lord, at the bottom, my lord, how on the what principles, my lord, we are I am trying to rely upon. My lord, I find, my lord, the paragraphs, the paragraphs are more or less written. It is there because, my lord, some judgments are there, my lord, will find where, my lord, there is no paragraph in the judgments.
Yes.
Only, my lord, in some cases the relevant portion which is there, that has been mentioned in the respective page of that judgment.
All right.
And if my lord, once, my lord, I can place the judgment, it will take my lord's time because I my lord, humbly submit, my lord, after going through the judgments, my lord will deliver whatever be judgment. After making a little bit of research, my lord, I find all those judgments. And my lord, the one judgment is not there. This is on the doctrine of precedent. এইটা বলা নেই ওখানে লিখে নে 2008 volume 2 SCC page 553. My lord will find the relevant portion at page 536 of this judgment. It's a quoting, my lord, from another judgment where it has been recorded circumstantial flexibility. One additional or different fact may make a world of difference between conclusion in 2 cases. Disposal of the cases by blindly placing reliance on a decision is not proper. My lord has got it, my lord, the portion at page 536. So let my learned friend reply, my lord. If anything is
Yes.
required, I'll do that. My lord will kindly permit me for the time.
Lordship, this note contains 26 judgments. On the last occasion, my learned senior had cited 2, we had distinguished them, but your Lordship will kindly give us some time to consider this. 26 judgments, your Lordship, I don't know what is the relevancy of it, because if my learned senior has
He has
cited
not
them,
pointed it out. He has just given a copy of the same.
is your Lordship,
But if my lord says so, my lord, I can point out right now. It's not that, my lord. Since I have,
paragraph
I'm my lord,
was
supposed to
also not
submit the written notes, my lord.
You
There I have
file your written notes.
file a
There's
written
nothing
note.
unnecessarily. Don't delay it.
One leave, I'll just seek from your Lordship's
Yes.
I'll just seek your Lordship's kind indulgence for one aspect. While the matter was being argued before Justice Chondo, we had already cited one notification issued by the government of West Bengal, which says that the civil court's permission is not required. we'll just take your lordship's leave to
That
withdraw.
notification is here, 25/8/2021.
Lordship, that is there. Just put,
That is, my lord, on the basis of a judgment of 2009. That if the judgment itself is bad, my lord, the division bench judgment is there.
You file your written notes within 2 days.
But if-
says your lordship.
Yes, within 2 days.
Hmm.
I'll finish it off in the holidays. What will I do?
my lord, if-
If it would be a
No, not at all. Let me finish it
should
in
your
the
lordship
holidays.
should your lordship direct, we'll definitely comply with that.
File it before, by Friday, file it in the first half.
Lordship.
my lord, I want to make myself clear, my lord, because the
Heard.
judgments I have handed over,
Yes.
my lord, once not I can place one after another.
No, it's okay. I'll go through it.
Because in the
Lordship.
written notes, my lord, I have.
I'll go through it. I'll go.
Yes, my lord. ওটা দেখে নিন।
Would your lordship kindly allow us 10 minutes time to reply to what my learned
Yes,
senior
yes, you-
has submitted?
Yeah, you want to do it now?
Elegance, your lordship will do it now. Lordship, actually, the embargo that I am facing is that Mr. Banerjee is leading me in this matter.
That's all
If I
right.
had some more years of experience to embellish your lordship's wisdom with some able assistance, I would have done it. Lordship,
No, you
however,
can do a good job. Start.
I'll just incept off with two aspects that my learned
I have
senior.
to consider the rectified deed, how it has been done. It has been stated in the petition, admitted that there was no scope for lease or long-term lease or.
That you have already stated in
Yes.
that report which you have filed
Yes,
with the additional affidavit.
Lordship, with respect to the rectification of the deed, my humble submission is that your
Not
lordship,
with my lord's leave.
your lordship has already perused the translated contents of the rectified deed. Your lordship would, in your lordship's wisdom, your lordship would see that the only power that has been extended by the rectification is the grant of a long lease, which is substantially different from what we are trying to endeavor over here. Over here, our limited endeavor is to develop the property, and your lordship, the contention that the deity would be removed from the property, that your lordship is factually incorrect. Because your lordship, I've taken instructions from the learned client over here. There's been a portion of the property that has been earmarked for the deity to be reinstated in that position. Your lordship, in fact, the original Orpon-nama, which your lordship, my learned senior, is not disputed, that enumerates a provision which says that in the event that the property needs to be developed or certain rectifications need to be made to the existing property, which my learned senior had also placed the other day, a temporary arrangement will be made wherein the deity will be shifted to another location. The location has been enumerated in the deed. I'll showcase it to your lordship. However, once the rectification of the developments have been done, the deity will be brought back. And your lordship, that is sacrosanct. We are in no way trying to play with the conscience of your lordship or of the deity, where the deity's sanctity is compromised, your lordship. Your lordship, the other aspect that my learned senior has placed, your lordship, I'll just, no, sorry. Yes, your lordship, the other aspect that my learned senior has come out and pointed before your lordship, of course, your lordship's conscience has to be satisfied that there was locus or the constituent or attorney was empowered to carry out these aspects. Your lordship, over here, there are two Shebayats who are currently living. The third one had passed away and his son has now come into being. Your lordship, the original two Shebayats and the son, they have delegated, because your lordship, practically speaking, your lordship, these particular people in question, the Shebayats, they do not live in Calcutta anymore. So to carry out these aspects before the KMC or before the court, which is why your lordships will see that the writ petition has also been affirmed by the said Mr. Vinod Kumar Bhatt. So he has been authorized by a general power of attorney that has been executed in his favor. Your lordship, the other aspect by your lordship, when the deity is before your lordship,
Authorized by only 2 of the Shibayats.
your lordship,
Your
I'll just indicate that
Arpanama itself says that all surviving male
all
heirs.
surviving male. Your lordship, now the instructions that I had taken was that on the last occasion, the third Shebayat, who happens to be one, I'll just point it out to your lordship. Yes, your lordship, the third Shebayat, who happens to be Mr. Adhish Sinha.
Adish Chandra Sinha.
Adhish Chandra Sinha,
Yes.
he had passed away. So, your lordship, now in his place, he is issueless. So, in his place, there is no succeeding male heir who can come into his place, your lordship. So, the existing Shebayats, there are two Shebayats now. So, it will be the two Shebayats who will come and execute the general power of attorney in favor of the constituted attorney. So, your lordship, this aspect, your lordship, perhaps, and with the greatest of respect to your lordship and to my learned senior, of course, who has in his wisdom placed some aspects, your lordship will once again just kindly take page number 117 of the writ petition. Your lordship, the limited scope of query that was espoused by the KMC, your lordship, that we have already satisfied. Now, your lordship, by virtue of submissions from the bar, again with the greatest of respect, your lordship, these aspects, your lordship, cannot be gone into. Your lordship, the two aspects were, one was that there was a pending case before the learned Shialda court. Your lordship, that is dismissed for default. Your lordship, the other aspect that an order of the learned civil court would be required. Your lordship, this has been a settled proposition of law now. Your lordship, the civil court's permission for developing the property is, or for any aspect in that matter, is not required. Your lordship, the position would be a little different when it comes to a charitable trust. So there we are dealing with section 6, 7 of the Charitable Trusts Act, and that is read with section 34. Lordship, in your law, I need not embellish your lordship's wisdom in this regard. Lordship, section 1 of the Trusts Act essentially carves out an exception wherein a private devotha essentially need not go before a section 34 court for grant of permission before the learned district judge. Your lordship, the other aspects that have been proffered. Your lordship, again, my learned senior is correct in pointing out the submissions to the extent that the deity is a raya, what the Estate Acquisition Act would say. Your lordship, these are aspects that are not subsumed in the factual matrix of the present writ petition. Your lordship, the deities before your lordship through the constituted attorney who have been empowered by the two existing living Shebayats. Your lordship, beyond that, beyond the scope of query that has been proffered and enumerated in page number 117 of the, which is the offending document in the current writ petition. Your lordship, perhaps with the greatest of respect, these aspects the KMC cannot get. Lordship, my humble submission, I would just reiterate what my learned senior had submitted on the other day. Lordship, at the very least, will just grant us the opportunity to go back before the KMC. If KMC, and let them consider this representation in accordance with law, because your lordship, these superfluous objections, of course, your lordship, for the lack of a better term, your lordship, for rather extraneous reasons, your lordship, these are not tenable in law. Your lordship, the other aspect, your lordship, with respect to the tenancy, not able to collect rents, whether I have initiated any proceedings before the learned civil court for recovery of these amounts, your lordship, that perhaps, your lordship, while the Orphanama is silent on that, your lordship, that is a call that I will take, your lordship, because the practical embargo,
Yes,
once again,
that has got nothing to do with the sanction.
it's because your lordship would know in your lordship's experience, where go before the civil court for tenants who have been living for the last 60 years, the hurdles and embargoes that I'm going to face. So your lordship will, if your lordship requires that, if your lordship mandates or directs, your lordship, once more I'll just showcase the clause in the original Orphanama, which gives me the right to sell. Your lordship will kindly take page number 7. 1 minute. Lordship, I'll just place page number 67 and 68 read together once more with your lordship's leave. That would be internal page number 9. Your lordship, I'll place the translated document first. Because even I am inhibited with the Bengali version of this. The Shebayats shall be able to acquire any appropriate property, build a temple, and undertake repair work from the acquired income.
I already read that.
Your lordship, my learned senior has already placed these aspects. These powers are enumerated in the original Orphanama with respect to the power that needs to be accorded to one of these, to the Shebayats. For your lordship, the subsequent Orphanama, it's not really an amendment of it. It is only an extension to grant long lease that has been carried out in light of subsequent prevailing practical considerations. Your lordship, whether it is an explicit power to that extent ought to be enumerated in the original Orphanama, and your lordship, that is perhaps the wrong position in law, because your lordship, unless there is an absolute bar for me to do that, your lordship, I can go ahead and execute that. Even if I take their argument, even if I take their arguments at its Himalayan strength, your lordship, I can disregard the subsequent Orphanama that has been executed, because as I proffered to your lordship, that is only with respect to granting of long lease. Lordship, the power to enter into a develop agreement or to carry out certain repair works or to develop the property for the benefit of the deity, that is penultimate, or your lordship, that is Himalayan in everyone's understanding and endeavor over here, your lordship, that is not inhibited by the original Orphanama. Rather, there is an explicit, your lordship, for the lack of a better term, again, your lordship, there is an explicit permission, or your lordship, my learned senior is leading me in this matter.
Follow 2 minutes. Let me hear what you said. Argue.
Your lordship, there is an explicit power that has been enumerated in the original Orphanama. So even your lordship, if I may disregard the subsequent Orphanama, your lordship, that would not hamper or embargo my case. Your lordship, with respect to the two judgments that my learned senior had cited for the previous division bench, Your Lordship, 2008 to Supreme Court he had cited today. Your Lordship will just give me a minute. Your Lordship, 2016 SCC Online Calcutta 4476. It's one of the judgments that has been proffered in the note that has been handed over to Your Lordship. Your Lordship, this is a division bench judgment by of this honorable court. However, Your Lordship, the factual considerations that have been taken place here, that has weighed with the honorable judges over there, added with the fact that Your Lordship, in this judgment, the distinction has not been made as to a private devotha. What their lordships were dealing with over here was a public devotha, and it was a trust in general that has been dealt. So, Your Lordship, the precautionary aspect that I can go before the learned district judge under section 34, that aspect is always there with me. But the mandate of the law, Your Lordship, with the greatest of respect, does not direct me to go before the learned district judge. And Your Lordship, we have proffered a document, their document issued by the government of West Bengal, that Your Lordship, in his wisdom, has already.
Not government of West Bengal.
Lordship, they are the KMC. They are the instrumentality of the government of West Bengal with the greatest of respect. Lordship, secondly, with respect to 2010 SCC page volume 10 SCC page number 376, Your Lordship, this has also been a decision that has been placed before Justice Chondo when my learned senior was taking his case there. Your Lordship, this decision, Your Lordship, has no relevance with the facts and circumstances of our case because of Your Lordship, this decision entirely deals with the Estate Acquisition Act. Your Lordship, perhaps again with the greatest of respect and subject to what falls from the wisdom of Your Lordship, Your Lordship, the Estate Acquisition Act, Your Lordship, is not under consideration over here. Your Lordship, with that would be Lordship, my learned senior, if he has anything to add.
If I just 5 minutes, Lord.
He has done a good job.
Yes, Lord, I heard. He's otherwise very hardworking. I'll just to justify my presence, Your Lordship will bear with me for 5 minutes. May not have been necessary, but 2-3 documents, Lord, I'm given to understand. I did not have the benefit of listening to my learned senior friend, but I'm given to understand that an argument has been advanced that Shebites are not discharging their duties. Shebites are not before the court. The DT is a minor. DT can't come to court. And I can collect rent under the agreement. Why am I going ahead and taking these steps that are there? And the rectification deed has been done contrary to the Orponnama. The rectification deed, there was no authority to enter into such a rectification. Therefore, rectification can't be looked at. I'll just come backwards now. I don't think, and I'm conscious about the position in law, I don't think it is for the corporation to take this point. But without getting into this, disregards the rectification. The rectification only pertains to 2 aspects. One is actually in favor of the DT, because rectification says the money that comes has to be put into a bank account. We are designating a bank account in which all the money is supposed to become, and then we spend it in terms of the main deed. And the other is long lease. Look, I have now advised my client, because the initial Orponnama was so wide, the rectification is not even necessary. Initial Orponnama gives me the right to do anything with the property to the Shebites. So even if the rectification is not there, this is without prejudice to the contention that the corporation has absolutely no business to come and indicate what I'm supposed to do with the property. It's not within their jurisdiction. If this argument is made, then it is subversive of all the judgments that your lordships have laid down. The corporation can't get into aspects of title. One document, I must indicate, in principle, I normally don't do this. I have an objection to him handing over judgments like this. He has handed over a list. He's not cited a single judgment. He's handed over a list of 26 judgments, and he expects the court also, I guess, to read it by itself, and for me to read painstakingly every judgment and distinguish it. My lordship will not take this into consideration. I don't mind him placing the judgments, but let him not do this in thin air, not giving a list of 26 judgments which he doesn't rely on. And I burden the court of actually going through all of it and distinguishing it. There is no...
Save the honorable court's time, my lord. I submit it.
No, let him place it.
I can place the judgments. I don't mind. I don't mind.
You can't place 26 judgments.
Yes, my lord.
Be brief about it. the judgments which are relevant
Yes, yes,
to the extent of your argument,
yes.
you just point out those judgments.
Yes, well, that I have in my written notes, my lord, at right from paragraph 14 onwards. I have my stated.
No, sir,
Written notes.
you just point out those
Yes, yes.
judgments
No, I'm
which are
just-
relevant.
let my learned friend take the note. I'm giving it there.
নোটসটা আমি দিয়ে দিন
না নোটসটা কেন দেবো তোকে? না
তাহলে
এটা সাইমালটেনিয়াস দেওয়ার ব্যাপার, আমি তোকে দিয়ে এটা করতে দেবো না তো, তুই তো আগে বলে নিয়েছিস, আমি
You
বলেছি।
hand over a copy of your
he doesn't
written
want to
argument.
he won't cite the judgment. He
It's
won't
normally,
tell
my
them
lord, the
about-
written notes are not exchanged between the parties.
I am directing you to
Yes,
exchange it.
if my lord directs, my lord, I can do that. I have to do that. আর একটা কপি কোথায়?
কিচ্ছু দেয়নি জাজমেন্ট তো দেখায়নি
You give him on, where are your written notes? He
I'm
said,
not prepared. We were written notes.
But
He
I
was
have
supposed to
given-
argue today. I prepare it.
But then, my lord, I'm handing you handing it.
just hold on. You give your
Then
written,
let him indicate which are the ones he wants to.
which are the judgments you are relying upon?
Yes, my lord. My lord, first, my lord, EIR 2007 Supreme Court, my lord,
ওগুলো ঠিক করো।
number 1. ওই সিরিয়াল নাম্বারের সঙ্গে মেলাতে হবে।
On the ground?
Yes, my lord, on the proposition is the properties of temple and religious institution must be vigilantly protected from misappropriation and encroachment, especially by those entrusted with their management. Courts have a duty to safeguard such properties from wrongful claims. This is one. The next one is 1925 SCC Online Privy Council. Page 23, my lord. It's, my lord, because it doesn't contain any paragraph as such, my lord. I have referred to pages 251, 252, and 259.
See, sir, you have put all the judgments in here. Just point out the relevant
Yes,
judgments
my lord.
which you are relying.
Relevance, my lord. Relevance I have given in my written note. Without even correcting, my lord, I'm handing
If
over.
he doesn't share the notes with me.
Yes, I shall.
No, sir, please do it here. Please, আমায় এখন দিয়ে দিন।
আরে একটাই কপি আছে, তোকে দেবো কোত্থেকে?
But I'm objecting
I'm
to this.
just-
Lord,
I'm
he
just
doesn't
handing over
cite
my
the
lord.
decision he wants
My
to
lord,
deal with.
within half an hour, I'm giving this.
See, the
Because-
problem is, unless until he knows, how will he rebut?
Exactly.
But I'm just getting it copied and I'm handing over.
Give a copy.
তোলা আছে?
See, I really wanted,
Very well, well, I'm handing it over.
I really wanted to finish it off in the vacations.
Yes, yes.
I don't see the kind of assistance.
I'm handing over after referring this much, I'm handing my copy itself. I'm handing it my copy itself. You'll also be kindly see.
26 judgments, your lordship will not allow that.
No,
No.
You can rely
I
on
do
any
not
number
know
of-
where any such
He doesn't
restriction can be
cite
given.
even
Any
one.
number of judgments he can rely upon. I can't
But let
restrict
him
him from-
cite those so that there is a procedure that we always
I'm
follow.
citing, I'm
Yes,
giving
citing.
citation. That's why it's not that any unreported judgment is there.
Yes, show the page numbers. What are you showing?
Yes, my lord, at page 15, my lord will
See, the
find.
first, wait a minute. The first judgment which you have placed here is A.A. Gopal Krishnan
Yes.
versus Cochin Devasam. Now tell me the page number of this judgment.
And index is there, my lord, at the first page of the judgments.
Yes. Para 10.
Yes.
Are you
Read
relying
para
on all
10.
26.
Yes, all 26.
Read para 10, sir.
That is. Let him place these. He wants to rely on all 26.
Yes. I'm placing, my lord. The properties of deities, temples, and there were some boards required to be protected and safeguarded by their trustees, archaks, sevais, employees. Instances are many where persons entrusted with the duty of managing and safeguarding. the
How
pro-
is this relevant?
Yes, this is relevant because, my lord, the development agreement or the development of G+11 construction, no such specific provision is there in the original deed.
All right.
Original deed of Aparnama.
Next.
And, my lord, they said that the monetary crunch is there, deficit is there, the provision is there, my lord. They themselves will make good from their pocket or otherwise by way of temporary loan by them, and subsequently they can own it. The justification is not there.
All right. Next.
By setting up false claims of ownership, tenancy or adverse possession, everything is there, my lord. The first judgment is this. The next one, my lord, will find 1925 PC. Privy Council,
Yes,
page 25, my lord, Pramotho Nath Mulli.
yes,
Your lordship, kindly come to that. It's page 251.
yes,
My lord, 6-9 from the top.
yes,
It is sufficient to state that deity is, in short, conceived as a living being and is treated in the same way as master of the house would be treated by his humble servant. But I do not know whether the settlers have given the powers to the Sevites to that extent. Next, my lord, after leaving aside a few lines, the person founding a deity and becoming responsible for these duties is de facto and in common parlance called Sevite. What is Sevite, my lord? It is said.
yes.
Next, in the last paragraph of that page, it must be remembered in regard to this branch of law that the duties of deity from the time of consecration of the idol are the duties to something existing which, though symbolizing the divinity, has in the eye of law a status as a separate person. The position and rights of the deity must, in order to work this out, both in regard to preservation and its maintenance and the services to be performed, be in the charge of a human being. Accordingly, he is the Seviat custodian of the idol and manager of the estate, and so paying proper respect to the religious proprieties of the case. But then, my lord, in that case, my lord, the father, mother, and all these things are there. The next case is, my lord, 1931 SCC Online, Calcutta, paragraph 2. It appears, my lord, has got it, my lord.
Yes,
It appears that according to the admitted and established fact in the present case that the trust was created was a private Devoto trust. Now the question is whether in case of this nature, namely a case of private trust like the present one, a civil court has got any jurisdiction to frame a scheme for a management and administration of Devoto property. That the civil court has such jurisdiction as would appear clearly from the observations of the learned judges in the case of Manohar Mukherjee versus Raja Pyari Mohan Mukherjee, my lord. A reference is there.
It has, what does it have?
My lord has got it, my lord.
yes.
The limited purpose only to establish my case, my lord, that why it is required, but it has been settled all along. This is the consistent view of this honorable court in up to Privy Council. Next judgment is, my lord, 1946 SCC Online, Calcutta 3. My lord, paragraph 3. Oh, paragraph 9 and 13.
That your lordship, forgive my interjection once. Lord, I understand. I just asked him. I understand he wants to cite all 26 now. But in that event, may I just beseech your lordship to allow us to come back on the other side of the vacation to deal with these more. If he's going to cite all
Problem
26.
is, I really wanted to finish it
No,
off,
I also want your lordship to finish this.
but if
Lord,
you want time, then
but if he's citing 26 decisions now, I will need that time. Lord.
My lord, it fell from on the
very few of them would be relevant
But I'll have to go through
for
all
the
of them.
purposes of this.
Lord, I'll have to go through all of them. Lord. If he is not identifying which ones he wants to rely on, he wants to lock, stock, and barrel hand it over to your lordship and to me.
No, never.
Your lordship
According
put
to
a
in my
query to
humble
him, which one- I also
understanding,
want to finish it. I'm the one who's in the
my
hurry.
humble understanding, my lord, I have cited all those judgments because I have got something.
No,
I was making a research
exactly my
because
point. Now he
Yes.
wants to cite all 26.
Mr. Banerjee, your unnecessary fretting about this, those 26 judgments will not have that relevance. I can assure you. He has put definitely a huge bunch in front of you.
Very well. Then let him conclude. I'll finish too.
next your lords will kindly consider.
But may I just come back in time? Just 15 more minutes.
Yes.
Come to, my lord, page 30, my lord, running of the judgments, my lord, paragraph 9.
Page?
Page 30, my lord, the judgment which I have just said, my lord, 1946 SCC online, my lord.
Yes.
I am reading, my lord. My lord, for 6, my lord, from fourth line, a dedication of a property to a deity is irrevocable, and the rules, if any, laid down by the founder at the time of dedication regulating succession to the office of the Sevais should be deemed to be irrevocable, and unless the power of revocation is given. My lord, the rectified deed of, my lord, thing is modification, revocation to some extent, and that too, my lord, will find the rectified deed of Orponnama, my lord, was signed by female member claiming herself to be the constituted attorney. My lord will have to decide the preliminary issues also, whether in the present form the writ petition can be maintained.
Yes.
Xerox হয়ে গেছে, দেয়া হয়নি না?
Give it to him. Is that? Yes.
On that aspect, my lord, will have to consider. Next judgment would be, my lord, 1981 SCC online Calcutta, page 93. My lord, the running page would be 32 to 34. Here, my lord, from in the middle of paragraph 3, my lord will find the opposite party raised a dispute as to whether, in the absence of any express authority, the trustee can effect sale of property. The two petitioners and the opposite party, by an agreement dated, agreed to refer the dispute to the court for opinion on the point. Then, my lord, at paragraph 5, your lordship kindly see.
Yes.
16th line from the bottom, my lord. On the facts of the present case, we agree with the learned subordinate judge that the question referred to him for opinion is one relating to the management and administration of the trust property. Under the provisions of section 34 of Indian Trust Acts, such a question relating to management and administration of trust properties should be referred to the principal civil court of original jurisdiction for its opinion. Section 34 may have conferred wide powers on the courts to authorize sale of a trust property by the trustee, even if trustee is not expressly authorized to do so by the deed where such a sale becomes necessity for preservation and development of the estate.
This
But
relates
that-
to a trust. Why are you reading it? How is it relevant?
Yes, my lord.
It relates to a trust.
Yes, it relates to a trust.
Let's confine
Relates to a
ourselves.
trust, section 34, because all along the writ petition has, my lord, based upon the trust. The submissions were made all along as a trust, private trust. I have, that's why, my lord, I have also placed this judgment. This way or that way, my lord will have to consider in this matter. Now, my lord will have to, my lord, make a differentiation between the Devottar, private Devottar by way of Arponnama, the distinction between the word Devottar and, my lord, that of trust. Characteristically, my lord, those are two different. Still now I am submitting. A Devottar is a thing, my lord, which is irrevocable. The terms and conditions are irrevocable, my lord. Even the settlers, subsequent to, my lord, dedication, cannot change the terms and conditions. Why then they, my lord, lose all their rights in respect
All
of
right,
the
Mr.
property.
Banerjee, go ahead.
Yes. And that way, my lord, it has been decided here under section 34 that the civil court, being the principal court of ordinary jurisdiction, my lord, has the power. Next judgment, my lord, will find 2016 SCC online Calcutta 4476, paragraph 6, my lord, page 35-36. This is a judgment, my lord, which was not considered by my lords in division bench judgment. May I read, my lord? My lord, from paragraph 4, I am reading. Admittedly, Jyotindranath Chakraborty and others were the recorded owners of the suit property. They dedicated the suit property in favor of the deity Sri Sitola Mata Thakurani for Dev Seva out of aspect of this suit property. It is also an admitted position that Sharbani Devba became the Sevayat who sold and transferred the suit property in favor of the plaintiff's father. The plaintiff prayed for declaration of title on the basis of inheritance from their father who purchased the suit property from the said Sevayat. In this context, a question came up for consideration before the courts below as to whether the plaintiff's father could acquire any title in the suit property by virtue of such purchase of Devottar property from the Sevayat. Next, my lord, important. The suit property was dedicated to the deity. Deity is the perpetual minor. Sale of any Devottar property without obtaining permission from the district judge concerned is void. No permission was taken from the learned district judge for selling and transferring of the Devottar property. Even the legal necessity for which the property was sold has not been proved. Now, here the question why I was submitting, my lord, why the development agreement has not been disclosed. Had the development agreement between the parties, my lord, been disclosed before, my lord, but there is every reason to believe that there is a provision that the developer or the promoter will sell a portion of the property. This is, my lord, consequential. This is consequential. So whether that can be done. And this judgment was not considered by my lords in 2024 judgment.
You have a development agreement in place.
Your Lordship, we have a development.
You have placed it on record.
I beg your pardon. Your
Have you placed it on record?
Your Lordship, it is not on record.
Not on record.
Terms of the development. It was submitted before the corporation as
No,
mandated.
no. It's not there. It's not there. But many things are there.
Your Lordship,
I didn't go that much because since it is a different one. But it has to be placed when they are before my lord. It has to be placed on record. It has to be a material on
will
record.
allow us to file a supplementary affidavit, so we'll put it on record. Your Lordship, perhaps.
But those two things, my lord, repeatedly
Wait a
I am
minute, sir.
submitting
Wait.
that, my lord, power of attorney and the development agreement. Those are very important.
Both will put it it's submitted before this honorable court.
Yes. Yes, Mr. Banerjee.
Yes, my lord. But, next judgment, my lord, your lordship will kindly see 2000 volume 10 SCC page 376, my lord, at page 37 to 41. Here another interesting thing is there. My lord, this is the case, my lord, State of West Bengal and others versus Atish Chandra Sinha and others.
Yes.
But it is that Atish Chandra Sinha who is one of the person. From here, my lord, will find that there was a suit in 1958, suit number 111.
Yes.
And there everything was settled, my lord. The Devottar property was stated, estate acquisition proceeding was there. These properties were allowed to be retained. And my lord, Devottar properties were also there. There, my lord, will find one thing, my lord, will come. I have not argued, though I have not stated. One thing your lordship will appreciate, under the Estate Acquisition Act, there can be only one proceeding. To take the properties from the, my lord, intermediaries, only one proceeding under the Estate Acquisition Act.
Those are not relevant here.
No. Why I am saying, here, my lord, it has been dealt with, and my lord, there, my lord, will find.
Tell me the proposition which you are relying upon from there.
Yes.
What is the proposition you are relying upon?
Yes. I'm coming. I am showing, my lord, it is their property, and there, my lord, will find the endowment was, another endowment was there. The endowment was made in favor of the deity before 1892. I do not know, my lord, only in absence of those documents, I cannot make any
Go ahead.
details.
Yes.
Any details, because if once an endowment is made, if it is not another property, no further endowment could be made in respect of the same property.
Yes.
With respect to the specific land, it is therefore when dispute arose amongst the members of the family that an arbitrator was appointed. An arbitrator might have submitted some report then. Then, my lord, it has referred, my lord, to West Bengal Estate Acquisition Act.
Yes.
A plain reading of section 6(1)(I) of the West Bengal Estate Acquisition Act shows that if the property is held conclusively for religious or charitable purpose or both, then the said subclause will apply in order to determine whether the property is held exclusively for religious or charitable purposes. What is to be seen that, my lord, for that purpose, the deity will be treated as Rayat. And, my lord, it has been in paragraph 9, it has been held that that should not be an illusory one, it has to be genuine one. But many other things have come. If it is threadbare, it is stated. If, my lord, extends this jurisdiction, my lord, and goes
Mr.
into all these things.
Mr.
my lord.
Banerjee, you are the one who has put all these judgments here. So
Yes,
please
yes.
cite all the judgment and tell me the relevance of it.
Yes, I'm coming, my lord. Next judgment, my lord, is volume 30, Calcutta Weekly Notes, page 389.
Yes.
নামটা বলো
এই যে না নগেন্দ্রনাথ পালি।
লাস্টে দিকে
হ্যাঁ আগে পরে করে দিচ্ছিস কেন? বলিস নি আমাকে।
আমি সাইডে নাম্বার গুলো দিতে পারিনি তখন নরেন্দ্রনাথ পাল স্টেট আছে
নগেন্দ্রনাথ পালি কোথায় দিস? দ্যাটস ওয়াই আমি ওই দিন চেক করতে চাই।
ওতে ইয়েতে লেখা এই তো 150
Yes, madam, sorry. My lord,
page number 152 to 156
but at Nagendranath Pali, page 4258, my lord, your lordship will kindly consider page 152 to 156 because it doesn't carry any paragraphs as such.
Page?
Page, my lord, the judgment page, my lord, is 152 to 156. In the compilation, my lord, it would be, my lord, page 42 to 58.
Yes.
এটা কি দিয়েছিস?
তুই অন্য সাইটেশন আপনি
এটাই তো। এটা দেখিস না। এটা গন্ডগোল হয়েছে।
এই সাইটেশন অনুযায়ী এইরকম পেজ আর অন্য এসিসি অনলাইনের সাইটেশন অনুযায়ী 152 to 156
এই সাইটেশনটাই তো বের করেছিলাম না?
হ্যাঁ
এটাই তো বের করা হয়েছিল।
এটাই
Mr. Banerjee, probably even you would have not gone through all your 20.
No, my lord, I have at the outset, I have submitted, my lord, that I could not compare, my lord, after giving dictation, I left Kolkata. That is the reason, my lord. For this purpose, my lord, I said, my lord.
Listed for arguments after vacation.
Yes,
Listed for argument after vacation. You complete your judgments after vacation.
judgments, my lord,
Heard.
it will not be accepted
No, it will be accepted after vacation.
after vacation. Very well, my lord.
Would
The
you
lordship have
be pleased to direct us to come back on a returnable date?
বারবার করে বললাম বাবা যে মেলাবি এত কষ্ট করে না। তাহলে তো পেজগুলো তো
20th July.
তো
No, 22nd July.
না করে গেলে লাগবে।
Lordship, we'll be the ones who are prejudiced because your Lordship, I'll tell you one thing if I may trouble your Lordship with your Lordship, the decision of Atish Chandra Sinha, your Lordship, which my learned senior said that it's the same case. Your Lordship will see on the first paragraph itself, the deity is different, the property is different.
22nd.
None of these judgments. Lordship, 22nd, I won't pester your Lordship with this.
22nd July because I'm not here. I'll be in the circuit also.
Your Lordship.
My lord, would my lord direct my learned friend to produce or my lord file my supplementary affidavit regarding that power of attorney and the
No
development?
need.
At argument stage, sir.
না
Final
তুই
argument
জিজ্ঞেস
stage.
করলি বলি তো বললাম, আমি কেন বলবো? আমি তো আমার সাবমিশন করেছি, তুই যদি না জজ না অ্যালাউ করলে কি আছে?
Learned counsel for the, you file that. We'll see what is there in that. Learned counsel for the heard, learned counsel for the petitioner is directed to file a supplementary affidavit bringing on record the development agreement as well as the, what is that power of attorney?
General power of
My lord, to Mr. Baid.
Vinod Kumar Baid.
Development agreement as well as the power of attorney given in favor of Mr. Vinod Kumar. Baid. Counsel for the petitioner seeks 4 weeks time to file the same list on 22nd of July for further arguments. In the meantime, we'll see you file your written notes after that. We'll see that.
Very grateful to you.
Whatever.
We will file it there, then distinguish every judgment.
Yes, yes,
We'll see.
yes.
I thought we'll finish it. We wasted so much time.
And I'm sorry, my lord. I'm sorry, my lord. I beg to be excused.
VINOD KUMAR BAID. Petitioner আছে না?
Yeah. When yes.
Lordship, item number 5, I beg to appeal for the petitioners. Lordship, on the last occasion, your Lordship had, it fell from your Lordship that since there was an appeal which was pending, the appeal should be heard out first. Lordship, the appeal was listed and the appeal was heard out yesterday. Lordship, the server copy of the had just been uploaded. May I hand it over? Lordship, the subject matter of this writ petition, the self-demolition order dated 11th of March, has been subsequently stayed by the division bench. Lordship, I am praying that this matter be let go out of the list with liberty to mention, Lordship. Lordship, may I hand over?
But I was there. The matter was stayed, and contempt proceedings was also stayed. And the Honorable Division Bench has made some observations. My lord was also observing that. In any manner, my lord will see when my lord will go through the order. So, in any manner, my lord, that has been stayed, and that order which has been passed by our commissioner, that also has been stayed. So, I have submitted before the Honorable Division Bench that only 177 was directed to be considered by us, by the Commissioner. The Commissioner has no way out but to go through 177. But we ought to have gone on Rule 61 of the Honorable Municipal Corporation Rules 1990. That I will place before your Lordship whenever you have. So that was not considered.
The matter is to be taken up on the 26th of June, my lord. I beg for my lord to keep the matter in July monthly list if possible.
Better is this, my lord, adjourn it sine die, and thereafter,
My lord has made it part heard already. My lord has made it part
I
heard.
leave it to your lordships.
There's no question of
Probably hearing will take some time.
now whatever will be decided, we'll follow that. You have challenged which order was challenged?
Lordship, the 11th March 2025 passed by the Commissioner.
Learned counsel for the petitioner states that they have challenged the order dated 11th of March 2023 passed by the Commissioner, Havra Municipal Corporation in FMA number.
Lordship, there are two appeals, MAT 432 of 2025 and MAT 1673 of 2024.
So and so. Since the division bench is seized of the matter, let this matter be adjourned, awaiting the outcome of the above appeals.
It is adjourn sine die.
Adjourned sine die.
Liberty to mention.
Liberty, with liberty to mention.
Grateful.
They got a stay there, huh?
They have got to stay there. Fact, it was also troubling your lordships, I know. I was also being troubled because something was required to be heard out.
This whole retention fees which you have done,
That is 15 years back.
15 years.
And following Rule 61, that I pointed out before the Honorable Court. So
So only from 2017, the rule has changed, right?
Right.
The amendment took place in
My lord.
2017.
And we have no scope to consider any deviation. 7x said minor, but
Minor
this was not a minor. This was a one story.
It was one floor added.
One floor is there. But 61, Rule 61 says that one additional thing can be considered by the that at that time, 1990, as per 1990 rules. And I had no scope by the Honorable Single Judge to consider Rule 61. Only 177 was directed to be considered. In any manner,
I'll just come in 5 minutes.
grateful.
Item number 6, I appear for the petitioner. My lord, may I file the affidavit in reply, my lord, against the opposition, my lord, filed by the state respondents. I am handing over.
Yes.
My lord, it is appearing under the heading, my lord, extension of interim order, my lord. On the last occasion, my lord was pleased to extend the interim order.
Argue the matter on merit.
My lord, today, my lord,
What today? Why should
May-
I keep extending? This is not your right.
may I
Get the orders extended. It's not your right. Please argue the matter on merit.
But I am being led by my senior, my lord.
I can't help you, sir. I have given. Read the order, last order. What is the last order? It is made clear that the present petition relates to transfer. It is expected no unnecessary adjournment shall be sought by both the parties on the next date of hearing.
My lord, I have filed my lord reply, my lord. Only on a short, very short date, my lord. I'll come back
What do you mean short date? Short date will only be after the vacation.
on the day of my lord reopening, my lord, on the day of reopening.
I'm not here on the day of the reopening. See, transfer matters, you can't just sit over it and get a stay. How can you enjoy a stay on a transfer? Then you have filed your affidavit.
Yes, I have filed my affidavit in opposition, my lord. I have served.
You have filed your affidavit in opposition, but you have not given any ground why you have transferred him.
My lord, we have, my lord, quoted a rule.
Sir, rule is different.
Yes.
A foreign posting rule is a different thing. Why have you transferred? What are the grounds of
My
transfer?
lord, that is, my lord, in transfer order, my lord, that has been given.
Where is it given?
Yes.
Show me.
My lord, your lordship, kindly consider page 41. My lord, before that, my lord, kindly consider, my lord, that I shall place later. My lord, kindly consider the impugned transfer order at page, this is dated 30th August 2024. The governor is pleased to place the services of Krishna Kumar Singh, presently posted at Clark, Kaliaganj Municipality, at the disposal of Sector 6 Industrial Township Authority for discharging his duties as Clark Sector 6 ITA in terms of Rule 53 of the West Bengal Municipal Employee Service Rules 2010 in the interest of public service and until further order under the following terms and conditions. Now, your lordship will find that this has.
What is the reason, sir? You read it. Show
Yes.
me the reason. Where is the reason stated?
My lord, the affidavit in opposition.
In your affidavit in
Yes.
opposition, where is the reason stated?
Yes.
No, you said the transfer order itself shows the reason of transfer. Where is the reason of transfer?
My lord, in the interest of public service, my lord, that is the only.
In the interest of public service.
Yes. Now, my lord, the grievance of the petitioner is that he participated in a political rally, that photographs were circulated. Only because of this, my lord, he has been transferred. Now, your lordship knows, my lord, that transfer order can be challenged on three grounds, my lord. One must show that the order is without jurisdiction, or, my lord, there is any procedural, statutory violation, or, my lord, one must show that the order has been passed by someone, my lord, who has no authority. Now, here, my lord, your lordship, kindly consider the grounds of the writ petition, my lord. What is his grounds? Kindly see, my lord, page 16, ground 3. The first ground and the second ground are, my lord, usual grounds. Ground 3, it is manifest from the action of the respondent authorities who are acting in connivance with each other that the petitioner is being unnecessarily harassed and subjected to punishment under the garb of the transfer order owing to the said unfounded allegations made by the authorized representative of such and such political party, and the issuance of the said transfer order dated 30th August 2024 is nothing but a product of vengeance inflicted upon the petitioner. As such, there is no public interest involved behind issuance of the said transfer order as alleged or at all. The second one, my lord, is again, my lord, not in connection with those three exceptions, my lord, that if it is without jurisdiction or statutory violation, or, my lord, it has been issued with a malafide intention. Now, your lordship
How
will,
many people have you transferred from this municipality in the
my lord,
last 1 year?
from this post,
From this municipality,
my lord, that,
last 1 year,
my lord, I have no idea, my lord.
probably
That-
none. Take down. The petitioner has preferred the present debt petition being aggrieved by the notification bearing number 229 UDMA hyphen 25011 bracket 99/20/2024 dated 30th/8/2024 issued by respondent number 2 full stop. By virtue of the said notification, the petitioner has been transferred from Kalyaniganj municipality to sector 6 industrial township authority. It is a submission of the petitioner that such a transfer, whereby a municipal employee is transferred to the jurisdiction of another municipality or authority, is not a matter of routine administrative practice. Full stop. In the present case, the said transfer has been effected purportedly on the basis of a complaint received by the respondent corporation, alleging that the petitioner had engaged in political activities during the last general elections. Full stop. However, no show cause notice or memorandum was issued to the petitioner in this regard. Full stop. Upon learning of the existence of such a complaint, the petitioner, on his own initiative, submitted a written response. Full stop. Despite the same, the respondent number 2, without considering the petitioner's reply or affording him an opportunity of hearing, issued the impugned notification transferring the petitioner from Kalyaniganj municipality to sector 6 industrial township authority. Full stop. It is the contention of the petitioner that the said transfer is punitive in nature and has been effected in violation of principles of natural justice. Full stop. Respondent number 1 to 3 has filed their respondent 1, 2, and 3 have filed their affidavit in opposition, commencing with the assertion that the deponent has been advised to deal with those allegations which are material and relevant. Full stop. Upon perusal of the affidavit, it is evident that the respondent have failed to address the reason underlying the impugned transfer. Full stop. The affidavit merely asserts that the West Bengal Municipal Employee Service Rules 2010, the respondents are vested with the authority to effect such transfers. Full stop. However, it is not the case of the respondent that the transfer was undertaken for the reasons of administrative exigency or efficiency. Full stop. No justification for his unusual and exceptional transfer has been provided by the department, by the respondent. Full stop. In view of the above, this court directs the respondent to disclose the reasons for effecting such an unusual transfer, full stop. Accordingly, the respondent corporation is directed to file an additional affidavit within a period of 4 weeks from the date of this order, comma, clearly setting out the reasons for the impugned transfer. The petitioner is permitted to file his exception to the same within a period of 4 weeks thereafter. The full stop lists the matter after 8 weeks. In the meantime, the interim order is extended for a period of 10 weeks or until further orders, whichever is earlier. Full stop.
One thing, I'm for the 7, 8, and 9 for the municipality. He has made a representation to the chairman. The chairman has not passed the order of transfer. So that your worship kindly sees that he's not made the representation to the
You
chairman.
are for?
I'm for the municipality.
He is for the municipality.
No, he's for the state.
No, I am for the state.
You are for the state.
Yes.
What are you saying? You
He's
file your
made-
reply.
he's-
Why you have not filed your reply?
It's ready, it's.
You file it?
I had served it on him, but he refused to accept it, the petitioner. On the 15th.
A matter was ongoing, my lord.
Learned counsel for the respondent corporation has filed his affidavit in opposition. Affidavit in opposition of respondent number 7, 8, 9, and 10 is taken on record. Full stop. Learned counsel for the petitioner seeks and is granted 4 weeks time to file his reply to the same. List on. इसको डालो file.
একটাই তো আছে স্টেটটা পড়ে দিয়ে দেবো শোনো না তোমাকে পড়ে দেবো দিই
The copy has not yet been.
No, he refused. So,
A copy of the same is उसपे वो एक line लिख देना सौरभ. सौरभ. Saurabh. Copy of the Saurabh. A copy of the same is handed over to the council for the
I have served him a copy.
petition.
Lordship, in this matter, it's report was required to be filed, but let it be after vacation. 1 week after vacation, I will file that. It is ready already.
Lordship may then kindly grants us a liberty to file our affidavit in reply and the exception to the report.
They have not filed. Let them file the report.
As your Lordship, please.
Learned counsel for the
1 week after
respondent
vacation, I will file.
municipality, Mr. Banerjee seeks further time of how much time?
1 week after, within 1 week after vacation, I will file it. And
Further
serve it.
time of
Let them
1
file
week
extension
after
thereafter.
vacation to file his
এই এটাকে তোমরা ধরে রাখো,
affidavit.
immediate তাকে রিপোর্ট ফাইল করতে বলতে হবে।
So submit his report.
যতগুলো রিপোর্ট ফাইলিং না এগুলো সব তোমরা বার করো এক একটা।
Full stop. Reply to the same, if any, within 1 week thereafter. List after 4 weeks. Yes. 8-7.
8-7.
Deep day.
ওই জুলাই আছে।
Yes.
Malachip, Mr. Shodharam Jadal is appearing in this.
That is a
I'm a senior Malachip. I'll start Malachip. In the meantime, sir. Malachip, this is the affidavit in reply, Malachip. Supposed to file.
yes. Yes, tell me.
My Lordship, the report that was filed by the uh, respondent, my Lordship, that was a inspection. It was made on the property on the basis of a case that is, my Lordship, that is in page number. May I- one second. Page number 12 of the report, my Lordship. It's a MP case, my Lordship. Arjun,
Yes.
my Lordship. Thereafter, my Lordship. One second, my Lordship. And the my Lordship, my senior.
সবগুলো উপরেই তো ছিল সবগুলো দাও এগুলো কি
রিপ্লাইটা দিয়ে দিচ্ছি, ফাইল করে দিচ্ছি স্যার।
অ্যাপ্লিকেশন অপোজিশনটা করে অ্যাপ্লিকেশন অপোজিশন সবই ঘেঁটে ফেলেছ
Yes, sir.
Yes, sir.
I'm waiting.
My lord.
Waiting for your submissions.
My lord, this is my application. Your lordship was pleased to direct the municipality to submit a report in the form of an affidavit. And they have filed
Yes.
a report in the form of an affidavit, to which I have given an affidavit in reply.
Yes.
I'll come to that later. My lord, what is my grievance in this writ application? My grievance in the writ application is, my lord, that it is the private respondent it is a private respondent, my lord. Private respondent number 2 was constructing, my lord, a building without sanction of the municipality. There is a statute, West Bengal Municipal Act, under which the building rules have been formulated. And the building rule prescribes as to when either a construction, a rebuilding, a renovation, or anything is done with regard to a particular building, in that case, a building sanction has to be obtained. And the building has to be constructed in accordance with the sanction of the plan. My allegation was against my the respondent number 2 is that he was constructing a building without a sanction. But the proposed sanction plan that also I have annexed with my writ application. But one thing is very eminent, my lord, here, that respondent number 2, the private respondent, has not filed any opposition to the allegations I have made in the writ application. So, my lord, my submission will be that the allegation I have made against him in the writ application went completely uncontroverted.
There is no direction.
And should be deemed. My lord, I am not accustomed to interfere in the meantime. And in the appellate side rules, there is no necessity of any direction for affidavit. This is what I have heard. This is what I have learned. There is no necessity of filing any affidavit in opposition in the appellate side rules.
So, my lord, my submission is that it is totally uncontroverted, and according to law, it should be deemed to have been admitted. My lord, this is my first submission before your lordship. That the respondent number 2, against whom my allegation is there, has not come forward with any affidavit by controverting the allegation, and therefore it should be deemed to have
Respondent
been.
number, private respondent, Mr. So-and-so seeks and is granted 4 weeks' time to file his affidavit in opposition. Let this matter be listed after 8 weeks.
My lord, 4 weeks will be a little longer time.
4 weeks, 6 weeks. Granted 6 weeks time to file his
6 weeks.
affidavit in opposition. Reply to the same, if any, within 2 weeks, left after 10 weeks.
My lord, 6 weeks will be a little longer time, my lord.
Sir, challenge the order.
Pardon, my lord?
You can take it in appeal, sir, the order.
My lord, 6 weeks will be a little longer time.
It's all right, sir. Next.
Therefore, my lord, the court should not act according to rule of thumb.
No, sir, we don't act according to rule of thumb at all.
Yes.
We act according to.
Yes, my lord. My lord, it is a court of equity. 226 court is a court of equity.
Sir, I passed my order. If you agree.
Yes, your lordship has passed an order, but every order cannot be appealable.
All right. So next matter. Yes.
Item number 9, Mr. Ramdulal Manna is leading me in this matter, madam.
Totally unfortunate.
Well, he lays in courtroom number 11. Can it be taken up at 2 p.m., my lord? It's a request I'm making.
What
Item number 9.
After vacation, ma'am. I will be busy in 2 p.m. ma'am.
Well, let it be at 2 p.m. Affidavits are ready, my lord. It is ready for hearing.
Then we'll have it after vacation.
Yes, ma'am.
Let the affidavits be
At
kept
the
in,
request of the parties, let this matter be listed.
well, let the affidavit kept on the.
In opposition and affidavit in reply.
Well, then in that matter, can it be only not today or? my lord?
Can't have it now.
Nothing, my lord, I am doing. Municipality is here.
Affidavit in opposition filed by the respondent number 8 is taken on record. A reply to the said affidavit in opposition of respondent number 8 is also taken on record. Let this matter be listed on give end of June. 27th of June.
27th. Day play out.
27th.
27th June.
Day play out. How was the? Under the same heading, my lord? Under the same.
My direction was to file supplementary affidavit, my lord. I could not, my lord, take it after vacation, my lord.
This for
Because
the,
the entire building is out of electricity last 15 days, my lord. It's very difficult to get in touch, my lord. In court area, my lord. I shall file the supplementary affidavit, my lord, after 1 week of vacation, after vacation, my lord.
the petitioner was required to file a supplementary affidavit by enclosing a copy of the record of rights.
Record of
Record of rights.
My lord.
Well, after vacation, my lord.
Then 1 week after this.
Learned counsel for the petitioner seeks further time to file a supplementary affidavit enclosing the LR record of rights issued by the BLNRO. Full stop. Liberty is granted. Let the same be filed within. How much time? 3 weeks? Within 3 weeks.
After vacation, my lord. I have no.
Within 3 weeks, that will go after vacation. Within 3 weeks, list on 18th June. 18th June.
18 June. Anyway,
Ilan, I am appealing for the petition and I am grateful to your lordship for according to me yesterday I am on the virtual mode.
Yes.
This is relating to, my lord, tender in respect of pay and use toilet.
Yes.
Now, my lord, if your lordship kindly takes up the opposition file or the argument advance,
Where's Mr. Who's appearing for the municipality? Where's Mr. Ghosh?
Mr. Otis Kumar Biswas, led by Mr. Srijan Nayak is appearing. They are coming, my lord.
I'm
let
appealing
them
for the
start.
state respondent.
They're coming, right?
now, my lord, if your lordship kindly can turn to paragraph 6 of the, my case is that it was the practice which was adopted by the Calcutta Municipal Corporation for the purpose of running and or management of the pay as in use toilet. They used to raise bills or the advance bill for payment of the same for a particular period. And we have to deposit the said amount for which they are allowed to continue of that period. But in the meantime, they have floated a tender in respect of which the bills were generated and payment was made. On this background, my lord, I have challenged the tender notice not to give effect to the plot sites which have been given to us. On this backdrop, my lord, I have challenged this notice. Now, if your lordship may I turn to the answer to such allegation, is page 4.
Mr. Mukherjee, you are appearing for?
State. Page 4.
Page 4
of the evident opposition.
Yes.
The relevant portion, my lord, page 5 onwards. The denial portion is there, my lord. I am not. After that, it is also denied. 1, 2, 3, 4, 5, 6, 7, 8, 9 lines on the top. It is also denied. My lord, got it? That authority of the corporation renewed the contract from year to year. It is stated that to frustrate the tender proceedings, the petitioner agency paid royalty in advance for the purpose of operation and maintenance of the said pay and use toilet. It is also stated that the authority of corporation has not adopted any policy for revenue generation by inviting tender for operation and maintenance of the said pay and use toilet across the city, whether for the purpose of advancing better hygienic modern service to the citizen. The authority of the corporation floated tender for operation and maintenance of the said pay and use toilets across the city. It is also stated the petitioner agency deposited the advance royalty collusively to frustrate the tender proceedings. Furthermore, initially the petitioner agency was shown interest in the participation in the tender process already by way of written request, such and such. Therefore, it can be reasonably presumed the petitioner agency initially was agreeable to participate in the tender process, relinquishing their claim to continue with the operation and maintenance of the said pay and use toilet. Pause here for a moment and Malad, can you turn to my reply? So, two things, collusiveness, another is that I participated without any objection. Now, Malad, can you turn to page 12 of my evident reply.
Yes.
This is the complaint lodged. The complaint which have said that there is no tolerance regarding the corruption and other things. This is the complaint. And what is the outcome your lordship find? Page 17. Effort was made by saying, my lord, page 17, my lord got it. And last portion. In this regard, the IT cell of KMC authority has been.
Where are you reading? Page 12, right?
Page 17, my lord, the final report which was filed in terms of the complaint which lodged by my non-reference client.
Affidavit. You are talking about the affidavit.
Evident reply, my lord. Evident reply. Yesterday I have handed over to your lordship, my lord. Page 17.
Yes.
It starts on page 12, my lord, where your lordship find page 15 is the complaint which was lodged, which has been mentioned before your lordship, and the page 17 is the outcome.
Yes.
May I read out?
Yes, please. I can't read it.
Yes, my lord. Forgive me, my lord. This is certificate copy. I am reading out for last line. In this regard, 1, 2, 3, the last finding of the IO for the purpose of filing the final report. In this regard, IT cell of KMC authority has been trying to resolve it. There was no monetary loss of the KMC. As such, under order of superior, the case has been closed, declaring mistake of fact. So the statement made before your lordship on the basis of the evident opposition that something has been done, corruption has been done, and this is the outcome. Now, my lord, can you turn to page 18? Another thing for the purpose of participation in the tender process.
Page
18 in my evident reply, my lord.
yes. Is the earlier order?
Yes, that is why they said that I wanted to participate, my lord. Why? Page 18, your lordship will find the petitioner performing the work of maintenance at different locations. The petitioners claim that the contract between the petitioner and corporation is valid. It is another site. There, your lordship will find the petitioner. Next page, your lordship can turn to page 19. The leave was granted for participating in the ongoing tender process. Page 19, my lord will find last but one. Pursuant to that, my lord, it is not that I forego my right and participate. And after that, my lord can turn to page 20.
Yes.
The deputy chief engineer such and such mentioning that the tenders have been floated beforehand and the work order will be issued after September 2023. This September 2023 is the period till which the royalty was accepted from the petitioners. So it is not that it is 24, it was there in 2023 and it was held. It is another side, my lord. What I am submitting before lordship, it is the case which Mr. Naik wants to, that I have been doing something which is contrary to the interest of the KMC. Next, also, your lordship will find the
There
same
is a demand for
yes, demand I have annexed.
Where?
R1, page 9. Your lordship, once I can produce the original ones. Page 9 and 10. One is Arya Fatak. Next one is Taliganj Metro. At the top, my lord, you'll find the site.
Yes.
And I have paid the money that your lordship find from my writ application itself.
Yes.
Page 17 in my writ application, I have deposited that amount. There is no dispute. So therefore, my lord, it is their document. They are not denied. They made complaint in other proceedings. They accepted. Yes, said they will give effect to the same after the period of royalty. Amount of royalties they accepted that after that period. So the same argument was advanced for the coordinate bench also, and it was ultimately held that that is why the instruction was sought from the highest authority, the executive engineer. He said yes, will not do, and accordingly, my lord, in this tender notice, my lord will not find. My lord, can you pause here for a moment, and my lord, can you turn to page 44. They did not say from when this tender, the position will be handed over, and this tender, the site will be handed over, and the effect of this work order will be given. No, your lordship not find anything to that effect. Page 44, your lordship find the last date is bid opening, but the tender notice presupposes for 3 years from the date of handing over position, from which date nothing has been disclosed. On the earlier occasion, the same thing happens. So from which date you want to, the court is also, what it is also, from which date you want to give effect to. Nothing has been stated. In this tender notice, previous tender notice, in all tender notices. So I am praying that whatever the tender was, but the period for which you have accepted money from me, that period should be.
Yes.
Initially, my lord, we found that some of the writ petitioners in earlier writ petitions, they were coming with bona fide claim that we have received royalty. Subsequently, when we noticed it, we have found from our record that this was the scenario what we have stated in our affidavit opposition. We being the authority tried our level best to crack the entire racket. We have lodged complaint. That is the ultimate thing we can do. So far the investigation part is concerned, that is up to the investigating agency to prove, and in this present case, obviously they have failed to do this. But that doesn't create any right.
they have, it is admitted that they have submitted the royalty by way of a barcode, and that has been generated by some of the casual staff of our division, and we have raised allegation, raised complaint to that effect. And if your lordship takes up our affidavit in opposition, we have specifically pleaded under what authority they have made this advance payment. They have not prayed for any time. They have not asked any authorization that yes, we want to continue and we want to make it in advance. That permission.
The only thing is you answer this question that how you have raised the demand.
Yes, that is what I'm answering. In collusion with some of our casual staff, they have done it. We have.
No, but then in that case, see the investigation. You have withdrawn the case. You have made a statement.
That is the police authority who has investigated.
No, not police authority. It's on the basis of the statement made by your superiors.
Yes. No, your lordship in
Please read page 70 of the reply.
Page,
during investigation, complaint submitted a letter addressing to the Alipur PS. It could be learned that there was dispute in the programming system of KMC. It was the letter written by the higher official to stop this investigation. It is their authority.
Read your last line.
And it accordingly
under order of superior, the case has been cleared, declaring mistake of facts.
But what is there, I have produced before lordship. Now your lordships will tell you.
No, this is not me. This is some officer from your department has gone and made this statement on the basis of which the case has been closed.
And same, that is why the executive engineer have come before this court and said, yes, we will not disturb up to the date when the royalty was accepted.
That must be on the basis of 161 statement of any of the office. In that even we will have to further inquire into who has made this statement and what is the basis of this charge sheet. That
because this weakens your stand.
Ultimate findings of this charge sheet, let's say mistake of fact. Reasons, irrespective of the reason, finding of charge sheet is it's a mistake of facts. But so far our part is concerned, when we have detected something wrong, we have tried our level best to
Sir,
crack
this is your statement. Mistake of fact is not in the charge sheet. It is stating that superior from your department have gone and made a statement.
That is not specified yet. Who has made this 161 statement?
Whatever it is.
That is up to then them to produce. It is a statement noted by the investigating authority, but so far our part is concerned, we have tried to crack down the entire scenario, and we have taken all relevant steps to resolve the issue. Now it is I leave it to your lordship.
Heard. Reserved.
The interim is up to today.
Pass it. Pass it in the evening. File there, na mujhe.
He was making it save even.
Yes.
No.
Item number 12 to 21, my lord, these are all analogous matters. Lordship on previous occasion directed both the municipality and the state file their respective reports.
Yes.
The petitioners are all the residential medical officers. Some of them are still working. Maximum of them, lordship, have already retired, praying for post facto approval and disbursal of pension. The issue is no more recent, my lord. It has already been decided by the division judgments, but they are delaying this matter, my lord. I should get the post facto approval as per their own circular.
Where's the report?
Yes, my lord. My lord, I'm praying for 1 week extension of time, my lord, to file the report, my lord, because, my lord, the municipality, my lord, has not given the proper instruction, my lord, as per me, my lord, because, my lord,
State, you appear for the state. Where's your affidavit?
Kindly excuse me, my lord. Can you take it after vacation any day, my lord?
Only one affidavit has been filed, my lord, so far as item number 20 is concerned.
But 20, I am appearing, my lord. 20, filing my affidavit.
It is my reply
Give
to
the affidavit. Who's appearing in item This is 12.
I said
Who's
12.
appearing in 12?
In 12,
You
I
are
am for
appearing
the
in
state,
12.
my lord.
I'm for the municipal, in all the matters, my
You
lord.
are for the state.
12.
Take down in 12.
My lord, may I file my reply to their report? Because only
Just
one.
a minute, sir. Learned Counsel for the item 12. Learned Counsel for the municipality as well as the state seeks further time of 1 week to file their report in the form of affidavit. Full stop. Let the same be done 1 week after the vacation.
I should also get an opportunity to use an
Learned
exception.
Counsel petitioner seeks and is granted 1 week time to file his exception to the same. Let these matter be listed. We'll list it on 27th of June. All the matters. Wait, this is 11. Now 12. 12. Who's there in item 12? This 12, sorry, this 12, 13. 13, who's there in 13?
My lord, in all the matters,
All the
I'm appealing for the municipality, my lord.
All
He's
the matters.
appearing for a municipality. in all-
Municipality is fine. Who's for the state in 13? Same order. Check it.
Till 21, my lord,
13?
except 20. Except 20.
Yes.
My lord, they have not filed any report. 20, they have filed a report, and I am using my
13,
report.
14, 15, 16, same. 17, 18, same. 19, same. 20, may you just put it?
20, my lord, I am filing my affidavit, my lord.
Affidavit.
17, my lord, I am ready with the affidavit.
17. Pala 17.
But they have not served copy upon us.
Give a copy. You are appearing for the state, madam, right?
Yes, my lord.
Learned Counsel for the state has filed she has filed her affidavit.
Copy, my lord, here and now.
Report in the form of an affidavit is
It
filed
had
on behalf
item
of the
20.
respondent number 2. The same is taken on record. Learned Counsel for the petitioner is handed over a copy of the same. He seeks and is granted 2 weeks time to file his reply to the affidavit, reply to the report of respondent number 2.
State.
Full stop. Let this matter will date वही होगा, same होगा.
Item number.
Item 18 is the other where
The matter to appear?
they are taking time. Huh?
Item 21, I am also extended 1 week time.
18, they are seeking time, same as 12. All right.
Item number 14, my lord, I want
You're filing affidavit.
14.
Item 14.
When a copy may be served.
Item 14, Taman. Item 14, a report in the form of an affidavit is filed by respondent number 2, the state.
17.
Full stop. A copy of the same is handed over to the counsel for the petitioner who seeks and is granted 2 weeks time to file his reply to the same. List on same date.
Item 69.
ये डालो फाइल में डालो आप ये this is 14 right?
Yes, 14.
14.
17, my lord, laid the report. The form of affidavit. 17.
Yes. 17 already done. 18 we are giving date. Yes, 16.
I am paying for 1 week time.
16 time.
My lord, item number 15, I am paying for 1 week time.
15 also time.
Item 21 also, 1 week time.
21 also time. 20.
20, my lord. I am filing my affidavit, my lord.
20 the affidavit is taken on record. So and so seeks 2 weeks time. List on.
20.
And 21 is also there, huh?
20, my lord, state has also used their report. I have filed my exception.
All right. 20 में फिर वो change कर देना. State has filed the report and the exception to the same is also, where is it?
I have already handed.
Is filed and is taken on record.
The 20 respective.
This is 20, my lord.
20, item 20. 21. Who's in 21? For state, right? 21 state is there and she is there. So date, time. They are seeking same as well. 22.
Only till 21. my lord.
21.
And all will come on 27th of June.
27th of June.
Grateful.
How many pages? 23, 22. Or 22.
वो वाला है ना that
22 top, no?
22.
Lordship, most humbly, I beg to appear on behalf of the petitioner.
Municipality, my lord. I am
Lord,
taking 1 week time.
on the last occasion, my lord, Lordship was pleased to direct my lord to file the affidavit of service, and within that time, my lord, 2 weeks, my lord, we also have to file the reply.
My lord,
Still, my lord, the affidavit in opposition also.
my lord, I am telling you, lord, all the board was dissolved yesterday, my lord. My lord, kindly see the order of the, my lord.
But before,
All right. Learned comes for the respondent seeks and is granted further time of 2 weeks to file his affidavit in opposition. This is a respondent municipality, huh? Respondent municipality. Further time of 2 weeks to file. Reply to the same, if any, within 2 weeks thereafter. List after 4 weeks.
much grateful, my lord.
দাদা দাদা আগের দিন নামটা দেননি দিয়ে দিন
Yes, madam, I am appearing for the private escort.
My lord, I am for the Kolkata Municipal Corporation.
Lordship, I am appearing for the petitioner.
My lord, I am for the Kolkata Municipal Corporation, my lord. I was supposed to file a report. I was seeking a day's accommodation, my lord. I have missed the brief, my lord.
My lord, allegation of the petitioner is, my lord, I have illegal construction. I have a sanction plan, G+3.
You want to file your reply?
My lord, I was supposed to file a report, my lord. I have missed the brief today, my lord. I am seeking a day's accommodation, my lord.
But there in Calicut, take it after vacation.
There is a deviation, you know.
But there is no deviation.
Let the police. Let deviation has been detected. File the report.
Learned counsel for the respondent KMC seeks further extension of time to file her report. Further extension of 2 weeks to file a report. Let this matter be listed after 4 weeks.
The matter will appear.
I am obliged to your lordship.
After 4 weeks.
After 4 weeks, it will appear automatically.
After 4 weeks.
17/6.
Grateful, madam.
Very good.
Yes, Mr. Ahmad.
Yes.
What is it? What are you doing this side?
24, my lord. I am praying 1 day accommodation as my lord.
No. I can make the thing very easy.
I forgot to.
Because today I cannot break this premises before your lordship. What is the fate going on there? So may I pray before your lordship subject to
Asking only for 1 day, Mr. Ahmad.
I forgot to bring.
this can be the way of
instruction, my lord.
the initial direction can easily be passed. We do not prejudice anyone. Because what I am praying for before your lordship is this, a joint inspection by my client as well as the municipal corporation engineer. And my lord, and the other thing which I'm praying before your lordship is this. But that will take care of everything.
Lord, I am for the private respondent, my lord.
My lord.
You have the instruction.
Yes,
She has the instruction.
yes, my lord. But my lord, today, my lord, I forgot to bring the.
In fact, I have
Tomorrow, Mr. Ahmad.
I have filed
We have already. Tomorrow. Not today.
Yes. But I'm not filing my affidavit of service, madam, because
tomorrow.
they have already appeared.
Tomorrow.
They've already appeared. Isn't it?
And madam, where is she? She went away. Ensure that unauthorized construction is.
So, she will have everything.
Or we'll pass an order tomorrow.
Yes.
But 25 and 26, I am for the petitioner. This is the matter where my lord trade license is cancelled, my and shop is my lord not in operation since my lord March 15, 2025, my lord. My lord, on last occasion, my lord directed that my lord the records to be produced regarding my lord the hearing and cancellation of the trade license. My lord, in this matter, my lord, my humble submission is that my lord that the parties are at civil proceedings are going on, and I am enjoying an order of interim order of protection of my right. But in that, not only that, at the time when the hearing took place before the auditor who hold the hearing regarding the cancellation of my trade license, but at that relevant point of time, my proceedings before the learned rent controller was pending. and that particular document was produced before the learned rent controller. And not only that, and I have already made an averment in my writ petition in that regard. But that is why I'm seeking an
Your lordship,
supplementary affidavit to be produced, only to produce that the landlord has, my lord, is trying to evict me, and I have already filed a suit, and the rent control proceeding is there. And it is your lordship, I leave it to your lordship, my livelihood at my lord, since my father was in business, and the business is running since 1978. Or at this stage, if my trade license is cancelled, I cannot do the business. And not only that, my lord, the present trade license I have obtained, that also, my lord, when the parties are at, my lord, before the civil court, my lord, I am protected. I am also protected by the order of the civil court. My lord, that is why, my lord, using an affidavit with a advance copy upon all the parties, my lord.
What is this
So that
affidavit?
so it's a supplementary only to produce through the two documents, my lord. And our state and the corporation's presence is also required because they are to produce and satisfy your lordship regarding the records. That is, my annexure P8, my lord, page 5. This is of, my lord, rent control proceedings initiated by me against the private respondent landlady.
So how is this relevant for this case?
But that when the parties are at loggerhead and the landlady is trying to evict and stop taking rent from the tenant.
Sir, we are only seized of the matter to the extent of trade license, not beyond that.
Not beyond that, madam. When the parties, madam, they are before the civil court and the tenant is trying to protect his right before the civil court, in that case, madam, the asking for document from the landlady regarding the permission to operate the business for the purpose of getting the trade license. Madam, that is not possible. It's a very practical purpose that she will never give me that permission. That is why it is before your lordship. My lord, kindly adjudicate the issue in that regard. In that case, my lord, in any person, if wants to, my lord, do any business when has been doing the business, in that case, he will be thrown out of position. And this is the other way to get him thrown out of the position also from the tenanted portion. This is my humble submission before your lords. And my lord, I am protected by the order of the learned civil court also, that my right over there is protected so far as my possession is concerned. So the party will never give me, the landlady owner will never give me, my lord, any permission to run the business. That is, my lord, will adjudicate the issue only, because this is, I could not find any adjudication in that regard. I leave it to your lordship, my lord. I'll be out of, my lord, livelihood. Since March 15, 2025, my lord, my business is stopped. My lord, inform that premises. This part, my lord, kindly consider. I am beseeching your lordship. I have nothing to submit, only this aspect. And regarding the other illegalities that the trade license, initially it was issued under 1993 Act. It was cancelled under issued under 2006 Act, West Bengal Municipal Corporation Act, and it is cancelled subsequently under West Bengal Municipal Act 93. So that is ex facie, my lord, is not, my lord, permissible. So either way, and as on date, my lord, I am holding, my lord, a trade license regarding subsequent date, and my lord knows, and my lord's I know about your lordship's view that these online trade license subject to, my lord, satisfaction. But this subject to satisfaction, my lord, I can never produce any document, because the landlady will never give me any agreement or any permission to do the business. So in that way, I'll be evicted from the premises, which cannot be done directly. It can also be done, cannot also be done through indirectly also. That is, I am beseeching your lordship.
Yes.
I'm representing the state in, my lord, 6458 of 25, my lord. This is with regard to the inaction of the police.
That is subsequent, my lord.
একসাথেই আছে তো দুজন।
Mr. Nag is there for the.
Yes, Mr. Nag.
Last occasion, my lord wanted to see the file, my lord, where we had taken a decision. This is the original file, my lord. My lord, I'm not detaching any documents, my lord. I'm just handing.
Yes.
This is the reasoning recorded, my lord, for the corporation to cancel the license.
একসাথেই তো আছে, দুটো তো টাইপ করে আছে। পুলিশ কি করবে?
রিপিটিশনে বলেছে আমি খেতে পাচ্ছি না, তাই আমার অবস্থা। হ্যাঁ, আমরা একটা প্রেমিসেস বিগার বেটার সেম নেম সেম বিজনেস হি ইজ রানিং রমরমা করে চলছে। রিট পিটিশনে ওখানে and in repetition cases that I'm out of my livelihood.
You himself admit that he has been running the shop there for a long time.
Look, we are not saying that he was not running the shop. Look,
Yes.
there are two aspects. One is that when he went ahead and he applied for a trade license,
Yes.
there he was supposed to disclose few documents, which, my lord, at the online juncture, his
Yes.
self-declarations are enough.
Yes.
After that, a complaint was received because, my lord, if my lord sees the online certificate, there it is written that it is subject to the scrutiny by the corporation. So after the complaint was received, we scrutinized. We found that he cannot produce any document to sustain that he is having the possession correctly. This is one.
There's a rent agreement which was in existence earlier.
Correct?
Rent agreement was there earlier. It is that
He did not produce that.
My lord, there's never been any rent.
He did not produce that.
It's all submissions being made when
he
my
has
lord-
been an admitted tenant of yours.
my lord,
He's an admitted tenant. There are litigations to that effect.
we have never admitted, we have never acknowledged him as
There
a
are
tenant. We've never
ongoing
admitted rent.
litigation. There is a civil dispute.
My
There's an
lord,
order
that is
passed
a
by the
civil
court.
dispute that has been there pending separately. But lordship, the question is, he's saying he's been running it. He should have had a previous agreement. There must be an original agreement. There's never been any agreement. That's my instruction. He's been running it as a trespasser forever. Because of his political connections, extremely powerful person, we had to let him. We did not have a choice. But he was running it illegally from inception, and he cannot. Just because someone is running a business illegally does not mean that he obtains a right to continue to run it illegally. Trade license is only one of the documents. He's never had any clearance, lordship. The trade license which he has annexed, lordship, I'll show it's not an authentic document. And
my lord, may I submit two more things? While this matter came up, we have found the plan which was submitted by the office, person concerned.
Yes.
The plan is there in the file. I can show the plan.
Yes.
My lord, though our officers have found that the plan which is he has submitted, the number of the plan, my lord, in original, which has been submitted, is there in our records. But if my lord allows me, I can show the plan. The manner in which the plan has been submitted raises some questions. This is one. Second is the plan, the entirety of the house has been sanctioned as a residential plot where few shops are being marked. But so far as the municipal taxes are concerned, till today, there is no payment of tax in the rate of the commercial rate, which was supposed to be paid.
Your order itself says that
commercial.
Yes.
But I'm saying about the taxes.
Taxes.
The
are different
municipal
thing.
taxes were not paid, which we found out now.
That's
And
right.
my lord, there is a structural engineer's report submitted by the private respondents. That report says that because of like heat generated of this sweetmeat shop, the buildings is damaged. We have not verified it. If Millard directs, we will send our engineers to verify.
well, this aspect has been verified by the fire department, and fire department found that it was being run illegally. There is an order from the fire department directing them to stop all operations. That order has not been challenged till date.
Where
And
is
it was
that order?
disclosed 107 of my time. Lordship, it is page 107 of the CAN application which we filed.
There's an order from the fire
No,
department.
the order of the honorable learned single bench of this honorable court of coordinate with the earlier repetition, it has been specifically observed that the fire license is intact and it is in order. But may I point
Lordship,
out the order of the
what is-
earlier
Yes, sir.
coordinate bench?
My lord, may I complete my submission? submission?
Let him make his submission.
Yes, my lord, yes.
Your lordship will see page 107 of the CAN application, lordship. CAN 1.
We'll continue after lunch. We'll continue after lunch. I'll come.
Fine.
Just let it be. I have few pronouncements, so just.
What?
Oh, some mentioning.
Yes, Lord, under compelling circumstances, today morning I took leave to file the tender matter from Justice Sinha. From tomorrow, the determination is with your lordship, Lord. So it's extremely urgent. Kindly list it, Lord. Day after tomorrow, the leave is granted. Otherwise, Lord,
Justice Sinha's roster.
Justice Sinha's roster from tomorrow, it is given to my Lord.
Sir, come mention tomorrow, not today.
Lord, today the leave has been granted for filing urgent and for appearing day after tomorrow.
Tomorrow, come and mention it tomorrow, not today.
Tomorrow morning.
Yes.
Come for the judgment, my lord.
Where are the judgments?
Very weak to appear on with the petition. পরীক্ষার খাতা বের না
In the light of the foregoing judicial exposition regarding Section 573 of the KMC Act, this court is of the considered view that the issue of limitation as raised by the petitioner involves mixed question of law and fact and cannot be adjudicated upon in the present writ proceeding. The forum prescribed under the KMC Act is better suited for examining such factual dispute. In the instant case also, determination of the limitation issue necessarily involves an inquiry into the applicability of Section 182 of the KMC Act. Given the factual matrix, such inquiry falls outside the purview of this court's writ jurisdiction. In view of the above, this court declines to exercise its discretionary jurisdiction under 226. All issues raised by the parties are left open to be agitated before the appropriate appellate authority. Nothing stated herein shall be construed as an expression of opinion on the merit of the case, and this judgment shall not operate as condemnation of delay or extension of limitation for the purpose of any statutory appeal. The writ petition stand dismissed accordingly.
What is this?
Mr. Chakravarti, next time.
Lordship.
In the light of the foregoing discussion, this court finds no illegality or infirmity in the impugn order dated 10/8/2024. Full stop. The hearing officer has meticulously examined the relevant clauses of the concession agreement and has rightly concluded that the amount described as concession is in substance rent. This conclusion, forming the basis for the enhancement of the annual value, is supported by cogent reasons and does not warrant judicial interference. Furthermore, the procedural requirement under amended Section 184 of the KMC Act were duly complied with, inasmuch as notices were issued to the recorded owner and the recorded person liable to pay property tax. The petitioner, not being either, cannot claim a statutory right to a separate notice or hearing. No prejudice has been demonstrated to have been caused to the petitioner, particularly when the recorded person liable, i.e. respondent number 6, was duly heard and had advanced identical contentions which were appropriately considered and rejected. Accordingly, the present petition is devoid of any merit and is hereby dismissed.
Grateful, my lord.
Obliged, Lordship.
ये एक मैं लिख देता हूँ उसमें करेक्शन.
এখানে দাঁড়াও।
You got
to change it. Yes, sir. Yeah.
Well, we were showing.
Yes.
Well, we were placing page 107 of the CAN application. Now, Lordship, before that, may I make one submission? My Lord, in the meantime, the supplementary affidavit was served on us late last night. My Lord, we went through it during the recess. My Lord, whatever is stated, Lordship, the issues have sought to be intertwined in such a way that a completely different complexion has been given, which is not the real facts, Lordship. To that, Lordship, we'll need to file an opposition.
The supplementary affidavit.
To the supplementary affidavit, and we'll include the points in the writ petition as well, some of the submissions made orally are not borne out in the writ petition. In fact, they're contrary to facts on record, dehors the writ petition, which I'd like to deal with, Lordship, in our opposition. Because the ground in the writ petition is very simple. One, he claims that he is out of his livelihood. A shop was running, a shop has been stopped.
Depositing rent.
I'm depositing
Before the rent control.
Rent control.
Going on, my lord, before the rent controller.
Are you depositing rent before the rent control?
That proceeding is going on.
I understand. Are you depositing rent?
At present, I am not, because that proceeding is going on. Before that, my lord, before proceeding, I was paying rent to the landlady. Because on
Why you're not depositing before the rent controller?
My lord,
Why you're not depositing the rent?
that proceeding rent controller is absent. That is why the matter they have directed to file opposition to our application before the rent controller. That is going on. And before the civil court,
I was just.
But to that, may Lordship just clarify once.
During lunch, I was just trying to see some judgments to this effect. It's not that only this document is relevant. See, what you need to really see is the occupancy. And occupancy can be seen in forms of different documents too. You know, utility bill, it can be property tax, it can be many other documents.
But even electricity bill can be seen,
That's what I
provided
was
it is a commercial electricity meter.
Correct.
I do not know whether they have a commercial electricity meter or not.
Correct. Correct. But there are other documents also. So to insist upon the rent agreement, because that is the only basis on which you have not granted him the trade license.
But prima facie, we insist on that document so that there is no scope of taking over others' property. There might be cases which will
admittedly that he has been running the shop and there is a dispute between the landlord and tenant.
Perhaps this is
Whether
one
it's
of the
landlord or a trespasser, again, you know, we are not getting into that. There is a dispute.
But the reason of insistence is because there had been instances previously where we have seen that trespassing has been the fashion. To stop that, this was insisted. And not now, that is the main thing. And he also needs to show from his documents that, for example, the electricity bill. If he has a residential electricity bill running a commercial shop, that is not permissible. His occupancy can be only considered for a trade license if he produces a commercial electricity meter. Let him come up and say at least this much, that he has a commercial electricity meter there.
What do you have, a commercial or residential electricity meter in the property?
initially in my father's name, my father was running the shop. But thereafter, the letter of adjournment by the landlady. That electric meter which was there, that is running.
A residential electrical meter.
That is running, my lord. I did not change it, my lord.
Yes,
I must be candid.
You want to file?
Well, we want to file because, Lordship, I'll just point out, give an example as to why the submission was made that rent control has been approached. My Lord, what has not been told to your Lordship is rent control was approached after the Honorable Division Bench rejected his appeal.
No, before that.
He filed the suit.
Yes,
He
sir.
filed the suit.
Yes, sir.
My Lord, in any. One is he approached rent control after the division bench appeal was rejected. Not only that, he has made attempts before also to approach the rent control. That is all after I filed the writ petition, not before it. One. Two is whatever dispute, this suit he's talking about, he's obtained again filed after we have filed the proceedings, after suppressing everything in that suit as well. No mention of the proceedings before the Honorable High Court, no mention of the single judge's order, no mention of the Honorable Chief Justice's order, and they've got a suit, filed a suit and got an ex parte stay. Now, Lordship, all these facts, Lordship, we would like to bring it on record. Lordship will hear it out comprehensively. There is an issue to be decided. Lordship was talking with Mr. Nag before the matter was being taken out. There are issues which have to be decided. My lords will have all the facts before your Lordship, and instead of showing them piecemeal, we'll file a comprehensive objection. Lordship kindly decides the issue once and for all. We also want this issue to be decided because we've never wanted, it was a residential plot. These are powerful people. I had nothing to say. When I constructed my new house, I intended it to be a residential house alone, which is why I've been raising complaints from time to time that he's running a commercial establishment with manufacturing activity, being in a residential house without any clearances of law.
My lord, only one thing, my lord.
Yes.
On a continuous occasion, my lord, the submission is made that I am an influential and politically powerful person. My lord, kindly imagine in West Bengal, a person having political power would not have faced this type of problem of a certain cancellation of trade license.
How can you make that kind of submission?
Corporation has no influence.
Corporation is impartial. Corporation is impartial.
Very much impartial, my lord.
Corporation only works in accordance with law.
In accordance with law.
Right, Mr. Nag?
And my lord, only one thing, my lord, the document I have annexed in the supplementary repeater are all the documents which are with them also.
But this was
civil code
shouldn't have introduced to this
Don't make
procedure.
They want to
kind of-
file objection, my lord. That is not an issue, my lord. I leave it to your lordship, my lord.
That kind of
I'll
allegations
leave it to you.
against corporation is not right. Corporation is an independent statutory body
Absolutely.
functioning
Yes.
independently.
Yes. We love the utopian state of my thing, my lord. We always
And
love
advised also independent.
Advised also. All right, learned comes for the respondent, private respondent number.
Lordship. My lord, we are the respondent number 1, I believe. No, we are the private respondent number 2. কোথায় বলো?
হয়ে গেছে আর লাফালাফি
হ্যাঁ, হয়ে গেছে। আরে নিচে।
File it.
My lord, respondent number 5, Lordship.
Respondent
Respondent 5.
Since March, my stock is shop.
My lord, that should not be said, Lordship, because they have opened a much bigger shop. They have opened a much bigger shop. We will produce the evidence.
Within, will file his affidavit in opposition within a period of 2 weeks.
Lordship. Lordship, 2 weeks from vacation, Lordship, which is the last.
No, 2 weeks vacation will be why you don't function in
One,
vacation.
Lordship, I won't be
after
here.
the vacation.
My lord,
The
won't
matter
be-
will be listed after the vacation. You
Lord-
file it
My lord, then Lordship kindly provides for 1 week after vacation.
within 3 weeks.
Great,
That
great,
will go after vacation. Within 3 weeks, reply to the same, if any, within 1 week thereafter. Learned comes for the respondent corporation shall also file an affidavit bringing on record the reasons behind the passing of the impugned order of cancellation of the trade license. You file this in the affidavit. We'll file a report in the form of
File it,
affidavit.
yes.
Affidavit.
My lord, kindly
Kindly
fix the
record that
date
my lord, we have produced the original file as per the last day's direction.
Yes, the learned counsel for the corporation has produced the original file, original departmental file,
My lord, kindly
Same
fix
as
the returnable date.
returned back to the corporation. Otherwise, tomorrow you'll say the court only kept.
No. Absolutely.
My lord, kindly fix a returnable date, my lord.
Returnable date would be,
My lord,
problem is,
my lord, I leave it to your lordship.
24th of June,
Grateful, Lordship.
My
Millard.
Grateful.
because I'm not here.
My lord, I leave
But
it to your
25 and 26 will appear together.
Yes, both the matters to be listed together.
Grateful, Lordship.
But the other matter is absolutely
Nothing.
nothing to do with.
It's an
My lord, only
allegation
one-
against
only
the
one
police,
thing
my
is
lord.
that, my lord, it will be-
There was a direction of the coordinate bench to the police to see that the petitioner does not run the business without valid trade license.
They
They filed a police in action matter before Honorable Justice Siddhango Ghosh. He released the matter saying that since the matter is pending, similar matter is pending before your lordship.
They are not
it will be
running it.
The matter may retain its position, so that it can be disposed of.
Obliged.
Grateful, Lord. Much obliged.
My lord, I beg to appear on behalf of the petitioner, my lord. All the party have been served, my lord.
What are you asking?
My lord, the order dated 28th of February 2025 is under challenge before your lordship, my lord.
Where is that order?
At the page number 46, my lord. It's start from 45, but the specific order is at page number 46. This is an order. Before,
shut him out.
your petitioner have since revised sense of building plan, my lord, for the 4-story building, my lord. Issued in the year 2001, my lord.
What are you asking? Implementation of this order?
No, my lord. Kindly come to the page now 45, my lord. The first line.
Yes.
The fact of the case is below. On 25th November 2024, Shri Surajit Rai Chaudhary, Councillor of Ward number 10, filed a complaint before this office against Shri Shankar Prasad Sarkar. This demolition proceeding has been initiated on a complaint lodged by the Ward Councillor of Ward number 10. My property is situated in Ward number 9, my lord. I can show your lordship from the ARC copy. In next is page number 34, my lord. The left side of the page number 34, Ward number 9, my lord. There is no complaint lodged by the Ward Councillor of the Ward number 9, my lord. Even the Ward number...
Doesn't matter, sir.
My lord, if
doesn't matter.
The order passed by the chairman is without the consent of the Board of Councillor, my lord. Mike, the Ward Councillor of the Ward number 9 is a part of the Board of Councillor, my lord.
Your lawyer has, sir, all that is irrelevant.
My lord.
It is absolutely irrelevant.
No,
You
my
have a
lord. I can show you, lordship. Kindly
You
let
have a building.
My
Have
lord.
you done unauthorized construction?
No, my lord.
Your
According to
lawyer has admitted you have done unauthorized construction.
construction has been admitted, but it is illegal or unauthorized. It has not been admitted, my lord.
What do you mean it has not been? Read the order.
My lord.
Advocate
There
so
is
and so on
construction.
behalf of
There is
Sarkar
construction.
admits that the construction.
There
so
is
and so.
construction. I admit it. There is a construction, but it is
They have a sanction plan
my lord.
for the third floor, above third floor.
My lord, I have a
Show me
sanction
the plan.
fourth floor, my lord.
Yes.
Kindly come to the page number 30, my lord.
Yes.
Plan for revised 4-storage residential building.
Yes.
I have obtained sanction building plan for the 3rd storage building in the year 1997, my lord. That has not been annexed to the writ petition, my lord. Thereafter, my lord, completion certificate was given. Thereafter, for the 4th floor, my lord, I have revised sanction building plan issued in 2021, my lord.
Where is that revised building plan for 4th floor?
That is at page number 30, my lord. That has been annexed.
Page number
30. Annex P1, my lord.
Where is the 4th floor?
At the right side, my lord. Plan for revised 4-storage building. The right side. At the top, my lord. Plan for revised 4-storage residential building of Shri Amulya Ranjan Nag, who was asked by honor, my lord.
Where is the 4th floor, sir?
Revised 4-storage residential building. Plan of revised 4-storage residential building.
See your plan. The plan is only till the 3rd floor.
It is a 4th floor, my lord.
Then you are appearing for the
I am
corporation.
appearing for the state, my lord. My lord,
Who is appearing for the corporation? Dum. List nikalo.
You are none.
Further report has been asked from my lord, South Damdam municipality, my lord. But till date, they have not given the report, my lord, regarding the sanction plan, my lord. And my lord, regarding the unauthorized construction.
Even the inspection report has not also been served upon the petitioner, my lord, by the concerned municipality, my lord. In this case, and the petitioner has made an application for that, my lord. In spite of that, no inspection report has been served upon her.
Yes. Plan taker. Close the plan.
Page 3 of the report, my lord, the last page, my lord.
এটা পুরো এই স্টেপলটা যেখানে আছে ওখানে খুলে যাবে যেখানে স্টেপল করা আছে বোধহয় আমার ক্লার্ক স্টেপল করে দিয়েছে রিপোর্টটা মনে হচ্ছে এই পোর্শনটা In the hearing before the Board of Councillor, my lord, the concerned ward commissioner was not present. She has not interfered with the proceeding, my lord, and the order passed by the chairperson is without her consent, my lord.
Mr. Banerjee, you appear for Damdam? No.
And the most
Do they
important,
have the appellate authority also?
Municipality doesn't have not civil code is the appropriate authority. And
2000,
So the appellate authority under the tribunal is there, huh?
Municipal Act, there is no tribunal. Municipal Act, there is no appeal to civil code.
Civil court.
The second 118, subsection 3.
yeah. My lord, tomorrow is the date fixed for demolition, my lord. Tomorrow is the date fixed for demolition by the municipality, my lord. 22nd, my lord. Tomorrow, the day after tomorrow, I'm sorry.
You call, just see who's there for Damdam. Who?
Even Even my lord, I have, after mentioning my lord, I have served notice upon all of them, my lord.
I know how you serve notices. Is the name there? Can you give the number? I'll give a call. Call the concerned lawyer. We'll pass it over, call the concerned lawyer.
My lord.
Pass it over, call the concerned lawyer. Call the lawyer. Pass it over. हाँ उसमें भी देखना लिस्ट में और कौन है दमदम का. This is south or north?
South Damdam Hospital, my lord.
South Damdam. Somebody appeared today in the morning. South Damdam. Amresh Rai, no? I think he appeared today. Amit, call karo. Just call the lawyer. Give the details, call the lawyer. Tell him the court has passed over the matter, tell him to come.
My lord.
Mr. Banerjee, you have the number of Amitesh? Next. Pass over, pass over.
I am for the petitioner.
And I for the Howrah Municipal
Petitioner
Corporation.
has challenged an order of self-demolition passed by the Howrah
For the
Municipal
private.
Corporation. After this order was passed, my lord, we pointed out the lacunae in the order. Another order has been passed. Similar order, my lord, that there are side deviations, no extra floor. That order has been passed subsequently, which is again challenged in the subsequent writ application appearing in the list. In that, my lord, we have not made out a case that we inspected and found there are side deviations. We have made an application for, my lord, regularization of whatever amount is permissible under the statute, my lord, they can regularize. It's only side deviation, no extra floor. That application is not part of the writ application, the subsequent writ application, item 222. Now, this is the order of the, my lord, division bench, but in a similar case, my lord, a prayer was considered by the honorable division bench that they will have to pass an order on this. Kindly see page 3 onwards, my lord. Page 3 onwards, my lord, the point has been considered. After the demolition order, prayer was made for regularization.
কোন কোড? ডেভিয়েশন কতটা আছে দেখতে হবে।
800 স্কয়ার
ডেভিয়েশন কতটা আছে?
Yes, item 222 is not my other writ application, which is appearing in the list. Item 222.
Item
There will not the subsequent demolition order has been challenged and we have prayed for regularization. 222.
That is this, my lord, in each floor, deviated portion is 180 square foot. So, in each floor, 180 square foot, my lord.
Where is the other matter? ये
222. 222 of today's list. Today's list.
222 of today's list है fine.
তো 22 নম্বর একসঙ্গে হেয়ারিং হবে এই দেখো কত নম্বর item number 88 and item number 222.
2 points are taken there, my lord. First, that the application has been made after the demolition order, and that regulations have not been framed.
দুটোই দুটোই
ও তো অ্যাপ্লাই করেনি, ও তো মানছেই না।
চলো আমি করে দিচ্ছি। এটা করতেই পারি, আমাদের অসুবিধা কি? চাইছি
আমাকে একটা এটা দাও না, সাইটেশন অর্ডারটা। অর্ডার এটা দাও। না না
অর্ডারটা তো তুমি তোমাকে দিবে,
হ্যাঁ।
এই অর্ডারটা নিয়ে অন্য জায়গায় দেখাবে তো?
না না
রেজাল্ট কিন্তু সেম 0।
দেখাচ্ছি
আমি এতবার করে বলছি আমি ছেড়ে দেবো, আমার কোনোদিন কিছু বলে না, ফালতু কথা বললে হবে? ঠিক আছে বলো, আমি
একটা দিয়েছে, পরের রেটটা দিয়েছে, পরের রেটটা 222টা দিয়েছে।
In that case, my lord, I appeared,
Yes.
Sumitra Mukherjee. There are 2 floors also, extra 2 floors in that case.
So then you consider his
I can.
Your Lordship,
I'm
may I
telling
point out
that.
one thing, Your Lordship. Minor deviations have been allowed. The amount of deviation that has been pointed out by the Howrah Municipal
Let the commissioner
Corporation,
decide so.
that is more than almost 800 square feet, Your Lordship.
That is almost 180 per floor square foot.
4 floors, Your Lordship.
4 floors are there.
এটাতে কি হয়েছিল?
So দুটো এক্সট্রা?
না, এটাতে রেগুলারাইজ করেছিল।
না পাগল নেই। No, এখন ভাঙা অবস্থা চলছে, ভাঙা চলছে। The consequence in that case is already demolition is going on
it's going on.
after being rejected.
Other case is saying that the extra floors have not been, but I don't have any extra floor, but side deviations are.
Side deviations are there, and my lord, I humbly submit minor deviations have been allowed. 800 square feet in a building cannot be minor deviation, Your Lordship.
In the total area, whether it is minor, the
2 মাস পরে ভাঙবো, ছেড়ে দাও।
appropriate authority will come.
অয়ন একটা কিছু চাইছে ফর মেটেরিয়াল ইনস্ট্রাকশন, ও 2 মাস পরে ভাঙে।
Take down.
তো বলেই দিলাম দুটো
Petitioner has filed writ petition number.
এই কমিশনার না, 5 ইঞ্চি হলো গো।
Both the writ petition number WPA number 7973 of 2025 and
হ্যাঁ করেছে।
Page 50.
WPA number 1064 of 2025
No, এটাতে
are taken together. Full stop. In WPA number 7973, the petitioner is challenging the demolition notice issued
23 for 2020.
two petitioner or one petitioner?
One petition. Two petitioners. Two petitioners. Two petitioners.
Petitioners are challenging the demolition notice dated 25/3/2025 issued herein, issued by respondent number 3, alleging illegal and unauthorized construction in petitioner's property.
তারপরে সেই পরিণতি ওইটাই। এটা ভাঙা
What is the property? Property number 87A, right? That is the property number?
177.
Mahiari Road.
Premises number. Oh, premises number 87 by A, Mohiyari Road.
87A, Mahiari Road, PS Jagacha, Ward number 47, Havra. Full stop. It is the contention of the petitioner that the nature of unauthorized and illegal construction is can be regularized, and he has filed an application for regularization before the respondent corporation on 23/4/2025. Learned counsel for the petitioner, Mr. Ayan Banerjee, states that the nature of unauthorized construction and deviation can be regularized. Counsel for the petitioner relies upon an order passed in MAT number 860 of 2023, dated 17/5/2023, wherein the Honorable Division Bench of this court has held that the application for regularization of the impugned construction has held that the commissioner shall decide the application for regularization of the illegal and unauthorized construction after affording an opportunity of hearing to the appellant. It was further noted that since the direction, the division bench had given direction to the commissioner to decide the said application of regulation himself and not delegate his function to any other officer. The entire exercise shall be completed within a fortnight and from the date of communication of this order to the commissioner by either of the parties. In the meantime, the demolition order, in the meantime, no coercive action was to be taken on the property of the petitioner. In view of such observation, learned counsel for the petitioner prays for similar relief. Full stop. This court feels that since the application for regularization is dated so and so is pending before the respondent authority, this court directs the commissioner, Howrah Municipal Corporation, to decide petitioner's application for regularization within a fortnight from the date of communication of this order to the commissioner by either of the parties. Full stop. I have not gone into the issue of whether or not the appellant's construction is capable of being regularized. Full stop. The commissioner is only requested to take an independent decision in accordance with law. Needless to state, till a decision is taken by the commissioner in terms of this order, no coercive action shall be taken by the respondents in respect of the impugned demolition.
Opportunity of hearing may be given to the
Your Lordship, there is no further opportunity of hearing, Your Lordship. They have already made the inspection.
Commissioner Jalika na? the Commissioner shall within a fortnight, after affording an opportunity of hearing to the petition,
Matlab the
as well as the
Right.
concerned party or their authorized representatives. Full stop. Impugned demolition notice dated so and so. Since no affidavit has been called, the allegations contained in the stay application are the allegations contained in the petition are not deemed.
Your Lordship kindly records my submission that only minor deviation as per the Act can be regularized.
Learned counsel for the private respondent raises her objection to the effect that the petitioner has carried out unauthorized construction much beyond the scope of being regularized, and the nature of unauthorized construction is not minor but is in the form of major construction to the extent of
Almost 800 square feet in the entire building.
to the extent of almost 800 square feet.
And my contention also is that, madam. Let that be.
Full stop.
The council for the Honorable Corporation also says the same thing. Because this is not a minor, cannot be. But in any event,
Then I will dismiss it. Then let him take it to the division.
I am not.
You are saying that it can't be regularized.
It can't be because 180 in total floors is 900 minor.
Then I'll
800.
Then I'll decide.
No, I leave it to your lordship. Lordship can pass any order. I will not say.
I can, but then I don't want to.
Because this will
Mr. Banerjee, then it will be very unfair.
800 square feet they are saying in the entire building. There are 5 floors.
Yes.
If that is divided by 5 million, it's not more than 100 or 150 square feet per floor. If the
What
total
floors
area
are
is considered, how it shall be considered? The total area,
150 square feet.
total area,
floor is much. This
total
cannot-
area vis-a-vis Milord, the
in any manner, I leave it to you. Let
has
the
to be-
commissioner decide.
it
I
has
don't
to
know.
be-
I will not do any harm to anyone. But still, 180 minor thing. 180 is very major, not minor. Cannot be.
0.037 square meter. If I record yours, then the case is.
And as your lordship, I normally do not say this type. Only a commissioner has to decide it, but finally decision will be same.
But
kindly
consider Milord. If Milord, it is found that a certain portion is within minor, the rest
Then you
is
file your reply.
major.
Then you file a reply, then I will decide the matter.
I will fail.
Then you file your reply within 2 weeks, then strike down the order.
My lord.
Strike down the order.
Then
Then
I
I.
file my leave.
Let them demolish in the meantime, because if they carry out, then
When is the demolition fixed?
any
No, there is no scope for demolition immediately.
no, let
No date has been fixed.
They
We
will
are
not demolish.
already, no, that
Let
interim
them-
order may not be passed because
Then if they demolish Milord during the vacation, where I shall go? Let it be fixed Milord. Let the matter be made.
I'll decide it, don't worry. Then you change the order. Then you say that the petitioner has preferred the present writ petition seeking then he'll go to the division bench. Seeking quashing of the demolition notice dated 25/3/2025 passed by respondent number 3. Full stop. It is the contention of the petitioner that the said demolition notice has been passed without any application of mine. Full stop. Learned counsel for the petitioner states that he has moved an application for a regularization of the said deviation, said unauthorized deviation. Full stop. The same is pending adjudication before the Havra Municipal Corporation. Full stop. Learned counsel for the petitioner states that the nature of unauthorized construction can be compounded and has thus moved an application for regularization before the Havra Municipal Corporation. Full stop. Learned counsel for the respondent Havra Municipal Corporation, Mr. Sandeepan Banerjee, appears and states that the that the nature of deviation and unauthorized construction is more than
180 per floor, 180 square feet.
80 square meters.
Square feet.
180
Per
square
floor.
feet per floor.
Per floor.
And that the same cannot be regularized in
terms of the act.
In terms of the act. Full stop. He states that he seeks and is granted 2 weeks time to file his report in the form of an affidavit. Full stop. 4 weeks time. In the meantime, I'll give a direction to decide his application for regulation. The उसमें second वाले petition में कर लो. The petitioner, ये first वाला. The petitioner has preferred an application for regularization
that may be decided
of his unauthorized construction in property bearing number so and so. Full stop. Regulation application dated 23/4/2025 in property number so and so. It is the contention of the petitioner that the said deviation / unauthorized construction can be regularized in accordance with the municipal bylaws. Full stop. The said fact is refuted by the learned counsel for the. I'll record your submission. You are ready to decide his regulation application.
My lord, I can decide. If your lordship so directs, I will. I have to.
Learned counsel for the learned counsel for the respondent states that the is ready and willing to decide petitioner's representation dated 23/4/2025. Full stop. In view of the said statement, learned counsel for the petitioner states that he shall be satisfied if his representation is decided within a time-bound manner. Full stop. In view of the statements made by the counsel for the parties, this court directs the respondent, Howrah Municipal Corporation, to decide petitioner's application for regularization dated so and so, his representation dated so and so, within a period of 2 weeks, within a period of 2 weeks after affording an opportunity of personal hearing from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as the private respondent or any other stakeholder by way of a speaking order.
Right.
Full stop.
Only 3 weeks, 2 weeks in place.
3 weeks. 3 weeks. Full stop. And affidavit का 4 weeks दिया, 4 weeks plus give him 1 week to reply, 5 weeks. In the meantime, the demolition notice dated so and so
will be kept in abeyance.
Shall be kept in abeyance. Shall be kept in abeyance. Affidavit of service is taken on. Yes. No. Or even the first order was fine, Mr.
I'm sorry, my lord. I'm sorry, my lord. I have pained your lordship to draft it for twice. If your lordship so directs, again, my lord can direct. I will take care of that.
I think we will go by the first order. First order,
yes.
We'll go by the first order. You decide it.
No
I'll just modify it little bit.
Problem. No addition, nothing. We will abide by the first order.
Just dispose of.
Let it be disposed of.
In that event, your lordship kindly records my submission.
I have recorded your submission.
No submission of mine is required to be recorded.
I'm not recording yours.
Commissioner will decide.
28. Same order. Take both the petitions together.
Same order. Two or same complex, same order.
With karke.
Same premises, same order.
Yes. I'll decide it in terms of that order.
Disposed of.
अगर चाहो तो ये उतार लेना.
29
in terms of this. ठीक है ना?
29, 30.
South Damda municipality has come below.
Yes.
My lord,
Dispose it off.
my lord, I'm appealing for the South Damda municipality.
Yes, madam.
My lord, I'm praying for 1 day accommodation.
Yes,
because,
yes.
my lord, I have no instruction.
I know. That's why I called you,
Yes,
because
yes.
the date of
Tomorrow, my lord, I will.
tomorrow. That's the only reason. You have got the copy of the writ petition? Give a copy of the writ petition.
My lord.
Madam, please seek instruction, because the demolition action is fixed for day after tomorrow.
My lord.
He is saying that the construction is in accordance with the sanction plan. The sanction plan initially was for 3 floors. Then additionally, it has been revised. 4th floor has been added to it.
Yes.
If that is the case, then the order which has been passed is not correct. Please come with the report.
Yes, ma'am.
Give a copy.
My lord.
Report, my lord, I will take the
Virtual.
Yes, yes.
Just get the oral instruction also.
My
that's
lord,
fine.
already previously, my lord, the state has also asked for the report from the South Damda municipality.
State has nothing to do.
After getting it photocopy, my lord, I am sorry.
Give a copy
I
right
have to
now.
get- my lord. I have get
Otherwise, don't come and cry here that I have not given a stay. Give a copy so that she can take
after
instruction.
getting it the photocopy, my lord, I am serving in the court.
Give a copy. Whatever it is, take her number.
I have taken.
Give her a copy.
I have taken.
Yes. Next.
Great.
Bhawan.
কোনটা?
এটা 29 এটা অর্ডার হলো তো?
হয়নি এখন।
Not today, not today. Not today.
29?
29 years.
29?
27.
Which one is this?
29, my lord. 29, my lord, I am for the petition, my lord. My lord, here I have challenged the self-demolition notice, my lord, dated, my lord, 2nd May 2025, my lord.
What is the difficulty with the notice?
No, my lord, my lord, demolition order was, my lord, communicated to the petitioner, my lord, in terms of 177(1), my lord. My lord, the commissioner, my lord, the authority ought to have, my lord, served a copy of the demolition order.
Structure, no plan at all.
My lord, I have made an application, my lord, seeking regularization, my lord, before the
They have made the
but
construction plan.
the construction is there for last 60 years, my lord. But this is, I have taken out the supplementary affidavit, my lord.
What is there in the supplementary?
But I have made an application before the commissioner, but the praying, my lord, the regularization in terms of section 177(1) third proviso, my lord, which says, my lord, the commissioner has the power to regularize any unauthorized construction, my lord.
Minor.
No.
Minor. And that also, if any sanction is there, my lord, there can be a minor, but it is entirely, the building is entirely.
But the building is subsisting, my lord, for last 60 years, my lord.
What is the document to show that it's there for 60 years, the building? What is the document, sir?
But the registration is there, my lord, in 1990, my lord.
Registration of the land doesn't mean the building is in existence.
No, but
What is the document to show the building is in existence for last 60 years?
My lord, the registration was granted in, my lord.
What registration? Land registration?
No, my lord, the club. It is essentially a club.
Doesn't matter. I'm not concerned with the club. I'm concerned with the building.
But the club is
not concerned with the club, sir. I'm concerned with the building.
My lord, the kindly says, my lord, our deed was granted. I have by virtue of a deed, my lord, of 2004, my lord, I have annexed, and subsequently of 2008, I have annexed.
কত 60 বছর?
No, 2004, 2000.
Your lordship, so direct we can verify it then.
But since, my lord, I have made an application, my lord.
What application?
But before the municipal commissioner, my lord.
Just because you have made an application.
Yes, my lord, I have made an application.
Doesn't matter, sir. Do you have a right to regularize, Mr. Banerjee? Mr. Banerjee, do you have a right to regularize the whole building? I don't think so.
Yes, my lord, my lord. Kindly says, my lord, 177, my lord, once kindly, my lord. Hard provides, my lord.
Here, my lord, I find that notice has been given to him But I don't know whether hearing has been given.
But hearing was given, my lord, but demolition order was not served, my lord, and statement of reasons, which,
That
my lord,
I have to verify.
but 177 1 says, my lord, demolition order has to be served, my lord. My lord, and the last occasion, my lord, was pleased to direct that to take an instruction whether demolition order was served upon the petitioner or not, my lord.
So now demolition order is served upon you.
No, no demolition order, only self demolition notice.
All right. Demolition order is, give him a demolition order. Where's the demolition order?
No demolition order was there, my lord, and section 177 says, my lord, statement of reasons has to be, my lord, the furnished to the. But
So give him the demolition order. I'll dismiss this petition. Give a copy of the demolition order.
That I can.
Learned counsel for the petitioner has impugned the order dated order dated 2/5/2025, which is
party.
This is a hearing notice, huh?
My lord, 172. My lord, hearing notice was given.
Which is a hearing notice under section
Club.
177(1) of the Howrah Municipal Corporation Act. Full stop. Learned counsel for the respondent has handed over a copy.
No, my lord, no copy has been handed over, my lord.
Give a copy.
I have to take a copy, sought for a copy, seek for a copy.
No copy.
But if my lord, they keep it up any day after the vacation, I will.
Give a copy and dispose it off. He has to challenge that.
No, my lord, nothing has been communicated, my lord.
Then my lord, let it be taken up day after tomorrow. I will come with.
Day after tomorrow, we'll dismiss this. Let him challenge the demolition.
Original demolition.
This is
And my lord, I have made an application, my lord, before the commissioner, my lord.
Sir, I'm not concerned. You challenge the demolition notice and the whatever application.
Private respondent.
My
lord, we have the private. We have not received the copy of the.
Yes, I have, sir.
Private respondent.
Order to amra debo. Apni আর কি করবেন?
No. I have not received the copy. Similar matters pending.
My direct 29 and 48, my lord was pleased to 48, my lord was pleased to direct that both the matters will be heard together. 29 and 48, my lord.
No order.
What is there in
48? Day after tomorrow, I will come.
Day after tomorrow, day after tomorrow.
48.
I kindly direct the
But keep both the matters together. Day
দেখি দিয়েছি কিনা জিজ্ঞেস করুন
Day after tomorrow, keep both the matters together.
একসঙ্গে করে নেবো তো
Take together. Not today. Not today.
Only not today.
Direct copy of the.
But day after tomorrow is the original side day.
Who are you?
Private respondent.
Friday has
Similar matter, 48.
We will see it day after tomorrow.
If it is not today, then it will come tomorrow. My lord.
Day after tomorrow.
Day after tomorrow is the original side day. Then Friday.
Tomorrow, we can take it tomorrow.
I have to bring a copy from the corporation because I cannot give a photostat copy to your lordships. I will come with, I told them. These type of copies are not required.
Tomorrow we can do it, no?
As your lordship.
No, demolition.
Tomorrow.
As your lordship, as your lordship.
For 29 and 40.
29 and 40.
Similar matter.
My lord, I am for the petitioner, my lord.
My lord, I am for the private respondent number 8 to 17, my lord. Private respondent number 9 in this matter has been died during pendency of the writ petition, my lord.
এটা কত?
Make them a party.
Make her party, my lord. Give me liberty to file the substitution, my lord, and fix this matter after vacation, my lord.
In all your matters, people die. Whenever you file. Last time also somebody had died.
Just yesterday it was.
Yesterday.
Oh, substitution. That
Substitution, my lord.
Substitution.
Then, my lord, substitution they have to make.
Who has died?
Pardon, my lord.
Who has died? Does it respond number?
Respondent number 9. Nilmuni Noshkar. On 5th of
Learned counsel for the petitioner seeks liberty to add the legal heirs of respondent number
9, my lord.
9.
Nilmuni Noshkar.
Since she has deceased. Liberty is granted.
30.
Let the heirs of respondent number 9 be added as party respondents to the present proceedings. Make them
party, my lord.
and fresh service.
My lord, after 2 weeks of vacation.
Put it after 2 weeks of vacation. 18th. 18th of June.
Grateful, my lord, grateful.
18th of June, 48 are here.
Yes, my lord. I am appearing for the petition.
My lord,
Municipality, my lord, led by Mr. Hon'ble.
Genesis of this case, my lord.
And is granted liberty to move an application to bring the legal heirs of respondent number 9. You have to move a CAN application for substitution.
Yes, yes, my lord.
Takes time to file a CAN application.
I will, my lord. I will.
File an application bringing on record the legal heirs of respondent number 9. Full stop. Liberty is granted. Let the same be done within a period of 3 weeks. List after 4 weeks.
Good.
I'm listing after 4 weeks. 4 weeks कब आएगा?
4 weeks, same calculated.
17/6, same date.
Yes.
Yes.
Please, sir. Yes. My genesis of this case is, my lord, the petitioners are asking for shifting of a public water connection which has been placed in front of petitioner's main entrance. May I place the number facts in nutshell? Originally, the land was purchased by the petitioner's number 1's husband. Subsequently, construction has been made, and during construction period, municipal authority placed a public tap in front of main entrance of petitioner's premises. As a matter of fact, during the lifetime of her husband, he made several representations for shifting of such public water connection in front of his main entrance. Whatever may be the reason why it has not been shifted, my instruction is this: there is adequate alternative space is there. After the demise of her husband, it is difficult for her because of the reason other two are the petitioner number 2 and 3. They are the married daughters. They are not residing there. The indiscriminate use of this water through that particular tap, the main entrance has become very much slippery, and once she fell down from the staircase and she was hospitalized. There was a fracture in the hip joint also. That is the situation, my lord. This is my humble prayer before your lordship. There is adequate alternative space is there. If it is possible, at least from my cost, it can be shifted. This is my humble submission. And my
encroachment on public
is,
land.
Yes,
All these stairs which he has made,
It
this is
encroached
all
the
public
pavement.
land. Demolish his stairs.
We are not the
Remove all the stairs he has constructed here.
Yes, my lord, but we are not that can be made by the DM, my lord. He is not a party. I am the municipal authority. My submission is that
You are for the state.
there is no
Demolish all this. Why don't you demolish it?
and the
Proceed encroachment on public land.
yes,
Lordship, we should Lordship with direction.
the total
What direction? You need direction to do your work.
No, Lordship, I have to make instruction, Lordship.
Take instruction. All encroachment on public land should be removed.
This is not
This is public land, sir.
yes, the whole staircase
living
is there.
space is there. There I have constructed this staircase. This is
All
my
this,
land, my lord.
all the staircase should be removed. Yes, tell me. What do you want? I'll get it done. Don't worry. Yes. What do you want?
Only my report.
I'll get this demolished and then I'll see your water. Yes, this is public encroachment, nothing else.
This is not really
So
giving
file a
space.
report. File a report. How much encroachment is there?
কোনটা pavement? Pavement কোথায় আছে? This is not the pavement.
Yes.
My submission, this staircase.
Party to
which
Korean.
the Lordship is,
Yes.
Party to Korean.
Yes.
for demolition. This
Yes.
is the open area which where I have constructed.
On open area, you can't construct, sir. You can't.
DM is not a party here, Lordship.
You can't construct. You're not allowed to construct in open area. This is not your land. This is not your
Only
land that you will
municipality and
construct anything
officer
you
in
want.
charge of the party, Lordship.
Not your land. So any open area, you'll go and construct anything you want to.
I will not.
Can you do that?
Absolutely.
Is it permissible in law? Is this your land? It's an open space. Leave it as an open space.
The difficulty one only.
You better withdraw this and enjoy the water connection which is in front of your house.
I have my independent water connection. And
So
everybody in the local-
let people enjoy the water connection.
I am not disturbing.
Yes.
I am seeing.
Otherwise, I'll disturb yours. Don't file these kind of petitions, please. They're frivolous petitions to be filed. When your house is not in order, don't come to the court. What do you want? Do you want me to pass order to get it demolished?
I'm enjoying.
Learned counsel petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn. Next.
My lord, I am appearing for the petitioner in this matter. In this writ petitioner, my lord, I have challenged, my lord, the construction of a factory shed, my lord, in a property in Uluberia, my lord, which is without a sanctioned plan, my lord. Now, my lord, there are companies, my lord, the respondent number 7 is the owner of the plot of land and the petitioners are shareholders in that company, my lord. Now, there are litigations pending in between the shareholders and directors, my lord. Now, this particular plot at Uluberia, my lord, 24 acres of land, my lord, there were factories which had been constructed. If my lord kindly takes page 77 of my application, I had made an application under the Right to Information Act to the State Public Information Officer of Uluberia Municipality, giving specific questions as to whether there is any existence of a building plan or not. We did not receive any response to this. My lord, we issued a demand for justice, my lord, and thereafter we filed the writ petition. After filing of the writ petition, my lord, we have received a response from the municipality. My lord, this is the response that we have received.
May I please your lordship, my lord, I am from Uluberia municipality, my lord.
My lord, in the response, it has been written, your letter in respect of the memo is seen, it is observed that the matter is under the Honorable High Court at Calcutta. Now, my lord, what is pending before this Honorable Court, my lord, is an appeal under Section 10F of the Company Codes Act, my lord, Companies Act 1956, my lord. That is in respect of the company and its functioning, my lord. Nothing to do with unauthorized construction in respect of the factory, my lord. Your allegation in respect of the RTI application is not true. Please find here the said reply video memo number such and such dated 25th of August 2023. Moreover, it is for your information that no record is found in respect of sanction of building plan of Wellcast India Private Limited. Now, Wellcast India Private Limited, my lord, is an entity which is, my lord, operating this factory at that particular place. Yes. But my questions, if my lord sees as page number 77 of my writ petition, it is not in respect of Wellcast or, my lord, any other company. The specific question was whether any plan was sanctioned or not. My lord, I have also mentioned in that letter, my lord, that the property is owned by, my lord, Sri Hanuman Cotton Mills Limited, which is the respondent number 7 in this writ petition. My lord, today I have a limited prayer before my lord. I am praying for, my lord, prayer B. My lord, I am not seeking demolition. I only want a report, my lord, to see whether there is any building plan which has been sanctioned or not, whether the structure which is standing there, it has some sanction.
So you had filed an RTI application?
My lord, I had filed an application.
What is the response to that?
My lord, the response we did not get. This is the response that I had handed over to my lord just now, my lord. Kindly see, I would not call this a response at all, my lord. There were specific questions asked, my lord, total of, my lord, 6 questions asked in my RTI application, my lord. The answer says that the...
Which page?
My lord,
Page.
my lord, page 77, annexure P4 to the writ petition.
This is your letter to the
My lord, the State
SPIO.
Public Information Officer, my lord, who I have implemented as my lord, the respondent number.
My lord, regarding respondent number 6, my lord, we have submitted that
Respondent number 5.
respondent number 6 and 7. My lord, respondent number 6, my lord, I am from Ulubela municipality. My lord, my junior is there, he is submitting the report, my lord. Mr. Saurabh Goswami, my lord. My lord, it is said that the construction made by respondent number 6 is wholly unauthorized. It was not constructed with the permission of the municipality. And my lord, regarding the respondent number 7, my lord, no specific report was given. My lord, your lordship would be pleased to direct the municipality to take a hearing and pass a reasoned order after giving a chance of hearing to all the necessary parties. I beseech your lordship.
Lord, this is, my lord, may I say this?
Yes, Mr. Chaudhary.
This is all set up, my lord. It's arranged to ensure, but matter now travels to the municipality, who will pass a demolition order and, my lord, tear down the factory shed. My lord, it is not surprising that the municipality does not have any records, because in 1952, prior to 1952, these sheds, my lord, were set up. And I'll show your lordship from the CLB judgment, my lord, that this company was acquired by this family in 1952. When it was acquired, there was already, my lord, an existing, my lord, foundry shed. Now, this is not, my lord, a structure. It's, my lord, steel joists. On top of that, my lord, it's sheds. On top of that, my lord, is asbestos. Now, the history is this. This was, the company was acquired, my lord, by the Kejriwal family. Ultimately, my lord, it carried on business. Father and two sons, my lord, started fighting. Matter went to the company law board. In the company law board judgment, my lord, it's clearly mentioned that, my lord, this company was taken over, my lord, in 1952 with an industry. Now, if it's pre-1952, my lord, shed being set up, there will be no records. We haven't seen, my lord, records ourselves. Puluberia municipality was...
Mr. Chaudhary, what do you want today?
Sir, I want to file an affidavit bringing all of this on record. He, my lord, is my contesting party in, my lord, the 10F appeal. Now, most importantly...
Mr. Saha, who are you appearing for?
But I'm led by Mr. Shah, my lord.
I'm sorry, Mali, I was just a couple of minutes late. Well, at the end of the day, Mali, your lordship is inquiring into only one issue. My lord, was there a construction made?
All stalwarts are here. What is this property?
I'm sorry, my lord.
All the stalwarts are here. What is this property? Yeah?
My lord, this is, my lord, a large, my lord, foundry unit. Now, foundry units, my lord, are, my lord, iron joists and structure. Now, there was an issue of demolition which came up, my lord, a few months or one year back. My lord, what had happened was, in the 10F appeal, Justice Tandon, my lord, had been pleased to pass an order of status quo. After that, my lord, we had extended the shed. They filed a contempt. Matter went up to, the demolition order was passed, matter went up to Supreme Court. We then came back to Justice Tandon with a remand, and we requested his lordship that please permit us, whatever we have extended, it's all temporary, we'll take it out. His lordship permitted us, sent the special officer again, and then, my lord, the matter went quiet for 1.5 years. There's no judge. We completed arguments, no judgment was delivered by his lordship, but the sting went off the whole thing. So, my lord, it's admittedly, or rather I shouldn't use the word admitted, but it's evidently, my lord, iron joists and a shed on top. Now, this is, so my lord, there can be no unauthorized construction per se. It's not a building setup.
But then that is for the municipality
Right.
to
No,
say.
number two, this has been existing from before 1952.
But all that you have to carry to the corporation, municipality, and they will decide that.
That's right.
See, this court can't decide
court
whether
cannot
the
decide,
construction is of 52 or 56.
but if it is a completely malafide proceeding filed by a person who's, my lord, not been able to gain success for demolition in the contempt petition, there's another way of, my lord, getting the same relief. Your lordship may be pleased to also consider that fact, whether your lordship will set the motion in. My lord, set the motion for all of this to be done. Let me file an affidavit, decided after vacation.
Affidavit of the municipality is more important.
No, municipality, my lord, seems to be with them.
That you can't say.
Yes, yes, of course I can say, my lord.
Mr. Chaudhary,
There is good reason to be able to say this.
That is not correct.
First day
The
he comes
municipality
and says, my report is there. He also says, we will decide, please send it to us. And there doesn't seem to be any permission.
If the
First day.
if
So
the
this
structure does
indicates
not
what
answer
is
the
what is in
correct
their
level,
mind.
then my lord, what is
Mr. Chaudhary, this
My lord, I want
disputed-
to, my lord, file an affidavit. I'll also, my lord, look whether
it
there
will
is
just
any.
enlarge the scope of the
No, no, I have a right to file an affidavit.
we will see that, Mr. Chaudhary, that whether the report, let us see the report which comes from the municipality. See whether there is any unauthorized construction or not. Let them take a decision on this.
My lord, municipality, my lord, they have, my lord,
There's no
prepared a
report.
report today itself.
Where's the report? I
Yes,
don't have
we
a copy
brought
of any
this.
report.
He's, I think, given this to your lordship.
I don't have any report, Mr.
Lord, he's been, my lord, brandishing it for some time, saying it's all against me.
Let us also have a copy.
Municipality will submit report from my junior.
Yes, my lord, please see, my lord, approval of plan from municipality is unavoidable to construct a factory, run a business. My lord, I have a factory's license. And I'll bring, my lord.
Factory license will not entitle you to have a construction in there.
No, my lord, maybe this is not to be construed as a construction.
Understand?
I'll show the act. My lord, I'll bring the act. I'll show your lordship pictures of the structure. Maybe this will not be considered to be a permanent structure.
Once the municipality takes a decision, it will be open for.
No, why are you so keen to go to the municipality? That's the main question.
Why is my learned friend avoiding it?
No, I want to allege malefides now before your lordship.
Malefides will not help this.
My lord, existing factory, which
Violation
is
of
running,
statute will not
half
have
of it
say
you
by
take
application
out. Now you're a shareholder. The other point, my lord, is Mr. Shah's client was, my lord, in control of this factory for 20 years.
No, my lord, this is
Now
not
suddenly you
Delta's
want to
factory.
say this.
He is creating.
No,
the
don't
factory
say, no, the records show this. My lord, I'll show your lordship, my lord.
Let them file the report. We'll see that.
Yes.
Let them file
The
the
municipality will confine itself to the nature of construction, my lord. Your lordship will be pleased to direct the municipality.
The petitioner has preferred the writ petition alleging.
Well, may I have your lordship's leave, my lord?
Yes, Mr. Sir. This was star appearance, Mr. Sir. This was star appearance.
Sorry.
Star appearance, just few seconds and then he's busy in the other court. Learned counsel for the petitioner has preferred the present writ petition alleging unauthorized construction on behalf of respondent number 6 and 7 on premises. What is the property detail?
My lord,
well, it is at page 77. The property details is there at my right information letter, my lord, that situated at 1507A, Jagannathpur, Phuleshwar.
Premises.
The entire address is mentioned.
Premises at 1507A/511A, Jagannathpur, Phuleshwar, Uluberia, Ward number 21, Havra. It is the contention of the petitioner that the respondent number 6 and 7 are carrying out illegal and unauthorized construction over the said premises without having any valid sanction plan. This land belongs to
The company.
7.
Land belongs 7, my lord.
It is the case of the petitioner. Further, it is the case of the petitioner that
my lord, it's on long lease to Wellcast. It's owned by Hanuman.
Owned by 7.
land in question belongs to respondent number 7, Shri Hanuman Cotton Mills Limited, a family-run company. Full stop. The petitioner is a shareholder in the company. Full stop. There is a dispute among the family members. Full stop. It is the allegation of the petitioner that unauthorized construction carried out on the said premise is in violation of the interim order dated 11/9/2013 passed by this court in APO number 210 of 2013, and hence contempt petition number 45 of 2018, which is pending before this court, which is still pending before the court. The petitioner states that during the pendency, the respondents are carrying out the said unauthorized construction. Full stop. It is further contended by the counsel for the petitioner that various representations have been filed before the municipality, before the concerned authority, but no action has been taken. Learned counsel appearing for learned senior counsel, Mr. Jishnu Chaudhary appearing for the respondent number. Mr. Chaudhary,
I think 6 and 7.
respondent number 6 and
I am appearing for my lord.
7 submits,
6 and 7.
submits that the said private respondent submits that the said construction has been in existence for past
Before 1952. That's our earliest record.
since 1952, and that they have not carried out any illegal or unauthorized construction on the said premises. Full stop.
And this is not, my lord, construction per se. It's a temporary structure which doesn't need
Further,
sanction.
He further states that the
It's a
nature
shed.
of construction which exists on the property is in the nature of temporary structures and cannot be constituted to be illegal and unauthorized construction. Full stop. Learned counsel, respondent municipality states that they shall inspect the property and will file a report regarding the said illegal and unauthorized construction. Learned counsel, the respondent seeks and respondent or the Uluberia Municipal Authority seeks and is granted 4 weeks.
Yes, yes, my lord.
4 weeks time to file his report, affidavit in opposition. Full stop.
Hearing
Affidavit in opposition. Reply.
Instead of 4 weeks, you are
4
telling 6
weeks
weeks.
after vacation.
How much?
Your lordship kindly fixes 6 weeks.
6 weeks.
8
6
weeks.
My lord, if it is inspected, my lord, they will go for inspection and notice be given to all the parties.
I will not let you enter.
No, I'm not inspection. I'm not cutting it out. Will seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. Full stop. Learned counsel for the private respondent number 6 and 7 is also seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. Let this matter be listed after 8 weeks.
Grateful.
Yes, sir, much obliged.
That contempt, Mr. Chaudhary, that contempt is still pending.
Contempt is pending.
That is the
tenure is
allegation that
pending.
during the period of the contempt, you are raising unauthorized construction. That's the allegation.
If the allegation, that
That
is
is-
the petition, that is the allegation.
That is the allegation, right? So that is,
My lord,
I just wanted to make sure that the record, what I've recorded is his context.
that is the allegation. But we have taken off everything.
Is
Lord,
taken
in
up.
that case, my lord, anyway, we'll do it after, my lord.
You get everything filed and then we'll see. Within
Much
6 weeks. 6 weeks. And 1 week thereafter for reply and list after 8 weeks.
Much obliged.
After 10 weeks, kar do na. Mr. Chaudhary, I'll list it after 10 weeks because they have sought 6 weeks time. They have sought 6 weeks time, 2 weeks to file reply after 10 weeks.
After 10 weeks.
Much obliged.
That will be 29/7.
No, the municipality will
My
inspect
lord,
that.
only that, my lord, municipality will
Affidavit.
intimate us before
Whatever they have to
inspection.
do, they'll
They will. Let them-
Mr. Chaudhary, 29/7, 10 weeks.
Much obliged.
But I don't know 33 one. I'm for the petition man.
I am appearing for state, my lord. এটা কি?
My lord, this is a matter of non-payment of pension and gratuity, my lord.
Idiots offense.
My lord, kindly.
Yes, your junior.
I'll
Oh. Yes, tell me.
Well, kindly come to a short list of dates, man.
Yes.
My lord, 10/3/2000, petitioner was appointed permanently in the post of lower division clerk. My lord,
Yes.
11/3/2000, in view of aforesaid letter of appointment dated 10/3/2000, your petitioner joined in the post of lower division clerk on 11/3/2000. My lord, 30/4/2021, petitioner retired from service. My lord, 11/2/2022, my lord, petitioner retired from service on 30th April 2021 after completion of qualifying service of 21 years, 1 month and 19 days. Well, kindly come to page number 12, my lord. 12.
Yes.
Well, PPO issued, my lord. Well, petitioner is not getting pension from last 22 months.
Who appears for the corporation?
Well, I'm applying for government, but the answering respondent is Tahirpur notified authority. This is the local bodies respondent of 4 and 5. And they have, well, as far as I have understood from their petition, there is a non-payment of gratuity, arrears of pension and gratuity. Some will come to paragraph 7. No, I am not the answering respondent. Answering respondent 4 and 5. Paragraph 7.
The PPO is issued by you. You are for the state.
No, yes, I am for the state, but the respondent is Tahirpur notified authority is the local body. Respondent 4 and 5. They are working there. He is working there. Kindly come to page 16, the last annexure. Last annexure. They have demanded payment from the chairman, Tahirpur notified authority. Well, we are the state, but they are the answering respondent. Well, they are the sanctioning authority. They are the disbursing authority. They have paid their dues as far as from paragraph 7 is concerned. So respondent of 4 and 5 is the answering
See
respondent.
who appears for Tahirpur. ये सौरभ वो लिस्ट में देखना ताहिरपुर म्युनिसिपैलिटी के लिए कौन है ताहिरपुर राइट
Tahirpur man. তাই তো নাকি
Tahirpur notified area.
নোটিফাইড ওরাই তো দেবে পয়সা ডিমান্ডও করেছে ওখান থেকে পেয়েছে ওখান থেকে
So this year you have to find the lawyer for Tahirpur municipality. Generally, I have a
Yes,
record.
Tahirpur notified area authority.
Notified area, my lord.
Tahirpur notified area authority.
Yes.
Tahirpur notified area authority, my lord.
Who is the lawyer who appears for?
I do not know.
Service
I do not know.
Yes, we have, sir.
Already served, my lord.
Every service, yes.
Every service.
Kindly take up after vacation, but in the meantime, they will serve a notice to Tahirpur authority.
Yes. But similar matter, your lordship has been pleased to fix on 23rd.
20
That matters matter, your lordship
Oh.
already fixed.
23rd.
Same municipality.
Same response. Same response.
Tahirpur.
Yes.
Then we'll have it on 23rd.
My lord. My lord.
কবে
Keep it on 23rd.
Sorry, my lord.
Not today, 23rd. 23rd. We'll have it on 23rd.
My lord.
23rd. আরে এই মাস
Yes.
Lord, I'm for the petition, I'm not.
Lordship, I am for Kolkata Municipal Corporation.
I'm for the respondent number 5. But I am the owner of a Lord G+2 building in Lord Kalighat area. Lord, the tenant was there. The tenant has expired during continuation of a suit. Now, Lord, his daughter has Lord converted the Lord particular shop room that the tenant, original tenant was in occupation into a hotel. Lord, I said, Lord, there is no license. There is nothing. Lord, illegally it is being continuing. I made a representation before the corporation authorities, Lord, for taking steps so that the hotel can be closed. Lord, LPG gas cylinders are being utilized, Lord, commercially without anything. Lord, please kindly comes to, Lord, the photographs your lordship would see. Lord, kindly comes to, Lord, page 44 onwards. These are the photographs, Lord, the manner in which the place is being used. Extremely dangerous. Congested area, my entire building. I will be held responsible tomorrow if any mishap happens. And recently, your lordship is dealing with, Lord, the already problematic situation of the rooftop. But those considerations, they had the trade license, whatever they had. This Lord, restaurant has or hotel has nothing. No food license, no Lord, fire license, nothing.
Affidavit respondent has also been made party.
You are the landlord.
I'm the landlord.
You want them to be out.
Look, suit is pending, whatever the recourse are out,
2013
Lord, that will take place.
Since
Now, Lord,
2013,
as
there
of
is a
date,
suit for ejectment that is pending.
that is there. Not,
Between
I have disclosed
the
that. I have
parties.
disclosed
And I have
that.
the valid license. I prepared a compilation. Kindly see the licenses issuing by the competent authority. All licenses we have. Kindly see.
Lord, a copy, Lord.
ঠিক আছে।
May I have a copy, Lord, from my learned friend?
Page 7 is trade
Pollution
license
control.
issuing from the Kolkata Municipal Corporation Authority.
So, license page. No, street license.
Page 25 and 26.
No, fire license.
Page 25 and 26. This is one of the certificate issued by the Fire and Emergency Services, and the Pollution Control Board also issued certificates in favor of the respondent number 5. Now suit is pending. They filed approach before this honorable
None
court
of
with
these
the allegation.
certificates were issued, Lord. I am not completely in dark. My land,
My certificate. My certificate.
Dark, sir. I can't help you.
My certificate.
What the allegations are not correct.
That's why I prepared the compilation.
Lordship, the license department has not been entered as a party also in the present writ application.
the license department, the corporation is a party.
Maybe, but the concerned department, the executing body, has not been entered as a party.
Can you see page 25? Next
But
date
all
of
the
renewal.
licenses, sir.
And next date is renewal of
Lord,
2nd November 2025. Fire license.
All read petition fill up.
Why should I entertain this petition? They have everything.
তারপরে এটা নিয়েছে
সবকিছুই তো রয়েছে
আরে সব আমরা ফাইল ওভার পর হয়েছে ভাই
কোনটা? Lord, kindly comes to my affidavit page, Lord, at page 14.
Yes.
Lord,
So you
it was
withdraw-
found on Lord September
Sir, listen.
2024.
You better withdraw this and challenge all the permissions which have been granted to them.
Lord, what I was Lord trying to impress
Or
upon
I'll
your
dismiss
lordship.
it.
Lord, what I'm trying to impress upon your lordship is, Lord, September 24, Lord, I filed this Lord writ
I
petition.
agree. Maybe at that point of time they didn't have anything. Let us assume for a minute what you're saying. I know what you're saying. You're saying that when you have filed this petition, they didn't have any requisite permission. There was nothing on record. All right. Today they have it.
So that's
Today they have it.
today they have it. Lord, apparently it
So
shows
you have to
Lord, they
challenge
have
it.
Challenge.
Rightly, wrongly. They have it. So all you can do is
Lord, I
challenge
see-
it.
Yes, Lord, apparently I see they have.
So, sir, you should withdraw this and challenge all the permissions granted to them. All right?
Cause of it. Lord, grants me 1 minute's time.
For what? For what?
1 minute's time. 1 minute.
Yeah, 1 minute. Yes, yes. I'll give you 2 minutes.
Lord, grants me a liberty, Lord, to come back, Lord.
You have all the liberty. Learned counsel, the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn.
Grateful, my lord. Grateful.
Great.
They were smart. They were smart. They stumped you.
Lord, next matter.
I'm saying they were smart. They stumped you.
Oh. Lord,
My lord, in this,
need to
regarding this 35, my lord, item, I'm appearing for the state.
Lord,
But
in
these days
this
you're always
matter, Lord,
appearing on. How's your? You're not well.
My lord, I got a hair crack in my foot. While moving to this court to that court, there
Therefore,
I
it
fell
should-
down in a very bad shape.
Lord, may I file the affidavit service in this matter? Lord, this pertains to, Lord, a 411 and 412 day notice issued, Lord. I did not have any notice, Lord, or Lord, no date of hearing was intimated to me by the corporation. Now, the issue here is the building was, Lord, declared to be a dilapidated house without even, my lord, taking any inspection. My lord, I have prepared from the structural engineer, from my lord, impanel structural engineer and the tenant of that.
You are the
premise.
tenant.
Yes, I have prepared a, my lord, plan, my lord, which certifies the structural stability of that, my lord, building, and there is no requirement to demolish for new building to come up. That's one aspect of the matter. The other aspect of the matter is, my lord, my lord, subsequent to this filing of this writ petition, I come to know, my lord, that they have obtained a sanction plan also, my lord, without showing me, my lord, as my lord, my space being, my lord, saved separately. My lord, grants me, my lord, some days time so that I can bring those on record by way of a supplementary affidavit, so that, my lord, your lordship can deal with it, my lord, comprehensively.
Take down. Learned counsel
May
for
I
the
just,
petitioner.
may I just educate, you know,
Yes.
the REIT is not maintainable. Why? Kindly have a look to prayer 11, page 11, the first prayer. I appear for the owner, private respondent number 6. This is an action challenged of the year 2017. Kindly look to the date 8/9/2017.
Yes.
Thereafter, these occupants were given notice. About 100 occupants were given notice. They all participated. They were heard, and consequent to that, a final order was passed by corporation. This is the copy of final order. Another writ petition was filed that they have not got the final order, but this is the final order passed by corporation. Consequent to this, sanction plan was also allowed. These petitioners were directed to vacate their premises, but instead of complying with the order of corporation to vacate, they may not have resumed it. Therefore,
Lord, first of all, my
the
specific
client said that they will vacate it so that reconstruction is made in terms of this plan. And corporation, I do not know whether is appearing or not, corporation has record that they all participated. Consequent to that, they were heard, and after hearing all parties, the final order in 2022 was passed. And this is the so-called notice challenge of 2017. Therefore, my lord, it has culminated into finality in 2022. Thereafter, sanction plan was granted. Construction, my lord, resumed on the basis of sanction plan. One or two occupant, possibly, I do not know whether my learned friend has instruction or not. I have been told that all the occupant have agreed to vacate the premises.
Lord, I don't have any.
Let
such
them take
instruction,
instruction
Lord.
because I
So
have.
that's why I said, Lord, let me
it's
come
all
back
right.
with a supplementary.
But all
affidavit
occupants
so that I
made a
can-
meeting that they will vacate it so that order of corporation can be given effect to and building is done. Because there was an accident in the year 2012. And it is because of the accident I was compelled to make the construction.
Since when
my statement in the writ petition is, Lord,
Sir, since when are you the tenant in this property?
I'm the tenant in this property.
Since when?
Lord, since Lord long. That Lord, I've stated, made
Miss,
that statement.
Miss Shabnam,
Yes, my lord.
you have conducted a hearing. Please find out whether this person was served notice. He was part of the hearing or not.
Yes.
My lord, for corporation.
Hearing
Yes,
for
Lord.
corporation?
Yes.
Oh, I'm sorry.
Yes.
Yes, let them, my lord.
All right.
That will not serve my purpose.
My lord, for corporation.
Yes, for corporation.
Detail হয়ে দাঁড়াচ্ছে,
No,
my
Lord,
lord. If
I-
not,
But,
Lord, see
but I'm appearing for the state
I'm not wrong.
For the state. Who's
right
for
now.
Corporation, corporation has taken hearing. Therefore, a
Obviously,
direction on how will
corporation
not
কে আছে?
suffice.
Who's for the? I thought she's for the corporation.
Mr. Olok Ghosh using
My lord, I can assist. My lord, my lord, I can assist, my lord.
let
You
them
can't
give a
assist.
notice to corporation because
You can't assist because the question is
My
towards
lord,
the corporation.
I can assist the court.
no.
Madam, the question.
Corporation, I can communicate to them.
তো আগে নামটা দেখো না।
Madam is here.
আগে
Yes.
বিটের orderটা দেখো না কে আছে।
No, corporation means law officer.
On the earlier orders, it will appear, my lord, KMC was represented. Let him serve a notice upon the lawyer representing KMC so that he can bring the fact that these are all.
I have filed that. That I can do, my Lord. Obviously, my Lord, I can
Or
do.
give a
There's no
notice to
difficulty on
KMC.
that, but I have served, my Lord, upon the KMC.
I do not know who is
She's here.
appearing, but
She's here.
previously, Mr.
Miss,
Ghosh in 18.
Miss so and so.
My lord, I can communicate this order to KMC.
My grateful, my lord.
Because as I'm also
Madam,
representing KMC,
I
but
already have
in
somebody.
this matter, yes,
I have
yes,
somebody.
my lord. Yes.
Miss
Let them communicate.
so and so who's present in the court is requested to assist this court in the present writ petition. Full stop. A copy of the writ petition shall be handed. Madam, what's your name?
Tanushree Dasgupta.
Tanushree Dasgupta. Miss Tanushree Dasgupta, who happens to be in the court and who regularly appears for the Calcutta Municipal Corporation, is requested to assist this court in this matter. A copy of the present writ petition shall be handed over to her. Full stop. Her appointment shall be regularized. Full stop. She seeks and is granted. Now this will come after vacation.
Yes.
Seeks and is granted 3 weeks time to take instruction.
Grateful to us. Because I
Not
think now
only,
this has become infractual.
Not only one thing, Lord, grants me also liberty to use a supplementary affidavit.
Possibly it has been not necessary because there is
That my lord will
if
decide when
necessity
I
so arises, he can file obviously.
My lord, one indulgence, if the petitioner is filing supplementary affidavit, my lord, let it be supplied with the state also, my lord. If supplementary affidavit is being filed by the petitioner, my lord,
Take
that
down
supplementary
उसके ऊपर
affidavit
लिख लो, the
to
present
be
writ petition has
served
been
upon the
filed.
state.
The present writ petition has been filed seeking withdrawal of notice dated 8/9/2017 issued under section 411 subsection 2 and 412A of the Calcutta Municipal Corporation Act 1980. Whereby declaring the commercial building situated at 263, BB Ganguly Street, Calcutta as dangerous. Full stop. It is the case of the petitioner that he is the tenant of the said building, and the respondent number 6, the private respondent number 6, is trying to evict him without following the due process of law. In December 2023, petitioner came to know that an order dated 8/9/2017 was issued by the respondent municipality under section 4112 and 412A of the KMC, declaring the said building to be dangerous. Any other writ petition which has been filed?
My lord, there are, my lord, so far I understand, my lord, there were 3 presentations earlier, but they have not pursued because they have we also have agreed to rehabilitate them. In view of this, the other occupants have agreed that yes, we will be rehabilitated.
So why don't you do the same with him?
Yes, we have done it. So I request my learned friend to take instruction.
I don't have any
We have instruction.
Then I'm not passing any
all.
order. You seek instruction. We'll have it
Therefore,
after.
let him seek instruction. If he
We'll have it after
let him seek.
after vacation. Then.
My lord, one line order, my
We are
lord.
agreeable to all.
No one line order, madam. Sorry.
At least
We are
grants me a
agreeable
liberty.
to all, not to exclude this occupant if he is in occupation.
At least grants me a liberty to use a supplementary affidavit in case, my lord,
My lord, that would reopen everything.
if
he is not satisfied, let him do so.
You come back after that.
Yes,
What is the
if at all there is necessity.
Presence recorded, your lordship.
No, then I'm not recording the list.
My lord.
Not today. Not today. Let this matter be listed after.
We will do to everybody.
Not today. Not today. Just
Because
keep
we
it.
are not going to make any
Keep it on
discrimination.
9/6. I'm not.
Grateful, my lord.
I'm going to keep it on 23rd of June. Mr. 23rd of June.
23rd of June.
Grateful.
No orders. I'm keeping it on 23rd.
My lord, one line order fixed it on 20.
No, madam. No one line order. You
Thank you.
enjoy your home. If you would
I
have
am at my
then I would have given you one line order.
No, my lord, I am at my court chamber only. Just doctors advise.
I'm not here. That's why I'm not.
I understand, Lord. My learned senior friend has been appointed for the corporation, Lord, because they did not appear. Lord, that I think, Lord, has to be recorded.
We'll see that. I'm not recording any.
Very.
Yeah, you keep it back. Mr.
Grateful, ma'am.
Affidavit service, you keep it back.
Grateful, my lord.
In this matter, your lordship was pleased to take up this matter on 25th of April. There's a direction upon the corporation to file an report, and by way of an affidavit and exception to be filed. I should be candid before your lordship that my difficulty, my problems, I could not get the exception. If your lordship kindly grants me a limited time, my lord, to file the
I am for
exception.
the respondent number 9.
Learned counsel for the petitioner seeks further time to file his exception.
Lordship, may I?
You want to file your exception, right?
Your lordship, may
The report, my lord.
Further, how much time?
Any time, my lord.
Further 2 weeks, 3 weeks time to file his exception.
The only thing that is a stay order, my lord, which would be, my lord,
To the report.
Your lordship, I am for the respondent number 9.
order would be in the ensuing vacation, my lord. If that can be extended for a limited time, my lord.
Your lordship, one contempt petition is pending in July 31st. May it be placed before July 31st, your lordship.
Lordship can keep this matter.
Regarding this flat only, regarding this premises only.
But there's a connected writ petition, my lord. Your lordship keeps the matter in the month of June, my lord. I'll come ready with my exception, my lord. We'll, my lord, can hear this matter at full length, my lord.
Your lordship, let one copy may be served of petition. Your lordship, I have not been served. Yes, written copy served.
You got a copy of this code.
Can
serve this code.
fine.
Just keep it after on 24th of June.
Written fine.
The interim order is expiring when?
At 25th of this month, my lord. That is within the vacation, my lord.
The interim order granted by order, which was the first order. In the meantime, the stay granted by order dated 29/9/2024 is further extended for a period of, which was subsequently extended by orders passed by this court, is further extended for a period of 6 weeks.
When the interim order was first passed on, my lord, 12th September 2024, my lord.
Yes. Which has been further extended periodically, is extended further for a period of 6 weeks.
Lordship,
Or until
report from the
further order
corporate.
File the Millard report, my lord.
Yes, file your. They want to file exception to this report, right?
Lordship.
A report of the report filed on behalf of the respondent. Report in the form of affidavit filed on behalf of respondent number 4 to 8 is taken on record. Petitioner seeks exception to file reply to the said report. List after swims.
My lord has been pleased to keep the matter on, my lord.
Tuesday,
Lordship.
24th.
Lordship.
Deeply.
Yeah, on behalf of the corporation.
Yes.
My lord, in this matter, I am appearing for the petitioner, my lord. My lord, I am the.
What are you?
My lord, I am the owner of the property for and staying there for last 45 years, my lord. My lord, the private respondent have constructed the illegal unauthorized construction made on the footpath, my lord, completely obstructing my premises. And at page number 20 and 21, mainly at the pictures, and my lord, at page 17 and 18, a representation was made to the corporation, but that has not been acted upon, my lord.
My lord, it's an unauthorized construction made on the footpath. We have done the FIR also, and we have directed for the demolition.
My
What
lord,
more?
my lord, that may be recorded, my lord.
You have a
Oral instruction, my lord, but
last time also you were getting caught in that oral instruction.
I have the copy of
I
this.
saved you last time. Don't keep these oral instructions.
I have a WhatsApp copy of a FIR. May I get a
We'll keep it tomorrow.
My lord.
Tomorrow.
কালকে রাখ বলেছে সাবমিট করেছি যে অর্ডারটা
Is your junior?
Yes, ma'am.
Then I can decide. I don't want her to be in trouble. You make that statement, then it's okay. Give me the file. You can make that statement, Mr. Banerjee. I don't want juniors to be unnecessarily. The department can always resile from their statements.
In any bench, I am very much scared. I rush before this court, my lord, because I know what happened.
No. So she is making a statement that you have already initiated an FIR and the
FIR,
demolition order has already been passed.
Already unauthorized construction, no plan, nothing.
So demolition order has been passed.
Demolition order has been passed.
So you are satisfied with that?
My lord, if that be so, then
Take down. The petitioner is the absolute owner and resident of 41E/1A Palm Avenue,
আমি দিচ্ছি তোমাকে ফোনটা, তুমি নামটা দাও।
Kolkata. Full stop. Petitioner is aggrieved by the unauthorized illegal construction carried out by the private respondent in front of his house and thereby obstructing his ingress and ingress. Full stop. Being aggrieved by the said unauthorized and illegal construction, the petitioner had preferred various representations. However, till date, no action has been taken by the respondent municipality. Full stop. Learned counsel for the respondent municipality, Mr. Sandeepan Banerjee, appears and states that an FIR has already been lodged against the private respondent for carrying out the unauthorized construction. He further states that demolition order has been passed against the private respondent for carrying out the unauthorized construction in the form of encroachment on public land. Full stop. He assures this court that the said unauthorized construction will be removed in terms of the demolition order within a period of.
That I cannot undertake, but Madam may record that it is expected that, or any direction may be given that it should be.
Since the corporation has already passed a demolition order, it is expected of the corporation that the same shall be
Statewide direction.
Same shall be brought to its logical end and the demolition order shall be executed preferably within a period of 8 weeks from the date of communication of this order. Full stop. In view of the said statement, learned counsel for the petitioner states that his grievances are satisfied and he does not wish to press the present writ petition. The present writ petition is disposed of in the above terms.
my lord, one indulgence may pay one indulgence, a copy of the order. If
for what?
My lord, because as
Has
I
already been-
perceive, my lord, subject to correction, that order has been passed in the month of January of 2024. Just
So that's why I'm given a direction. They have to comply with it.
my lord, about.
You have to, because direction is there.
Much obliged with your kind leave, my lord.
আবার কি? My petition, my lord,
I appear for the private respondents.
pursuant to direction passed by this honorable court, demolition proceeding was initiated. After filing the contempt proceeding, my lord, demolition order came. Now, my lord, demolition order, your lordship would get at page 98 of my application. My lord, kindly comes to page 98. At 99, your lordship would find, my lord,
What is your name? Sorry, I keep forgetting.
my lord,
What's your name?
Lord Rahul Kormakar.
Kormakar, right?
Kormakar. Lord, 99 kindly comes to page 99. Your lordship would find, my lord, two parts of this order. Part A is for demolition. Part B is for retention. Lord, I am before your lordship for implementation of this part A of this order because they are not acting, my lord, in furtherance of this order. Part B, my lord, I have preferred an appeal. My lord, that's pending. Whenever, my lord, that will take, my lord, it will be heard. It will be heard.
Who has preferred an appeal? They have preferred an appeal.
I have preferred an appeal because the retention could not have been allowed. Part B. Against Part B, the appeal is pending. Part A, I am before your lordship for implementation of this particular, my lord, demolition. Lord, I have taken instruction, my lord.
Lord, may I, my lord? Now, my lord, if your lordship kindly comes, my lord, to the order dated 7th October 2024 that was passed by this honorable court in this writ application. Now, my
Yes.
lord, if your lordship kindly takes up paragraph 2 of that order, lordship will find, my lord, it was recorded by this honorable court that Respondent number 628, my lord, that is I am, my lord, representing, however, submits that they intend to prefer an appeal against the order dated March 22nd, 20, insofar as it directs the demolition of the alleged unauthorized construction. List this matter after reopening. Now, if your lordship kindly turns to the next page, respondent number 628 shall be at liberty to take steps in accordance with law. Now, my lord, I tell your lordship what has happened. My lord, this order was passed on 7th October. The very next day, my lord, the court was closed for puja vacation. In the meantime, corporation was closed. The building tribunal was closed. On 21st of October, my lord, I went to the building tribunal for filing the appeal. Now, my lord, I had the photocopy of that order because certified copy was not provided to me by the corporation. So my appeal was not entertained. On 23rd October, my lord, I filed an application, my lord, before the corporation, my lord, for providing me the certified copy of that order. Till date, it has not been, my lord, provided to me. So, my lord, on 4th of November, that is the day when the court reopened after the puja vacation, my lord, I filed a writ application, my lord, praying for a direction upon the corporation to provide me the certified copy. That is item number 81 in my lord's list, my lord, in today's list, my lord. My lord, I don't know the reason, my lord. They filed the appeal, my lord, in December with the certified copy, but I don't know the reason why corporation is not providing me the certified copy. And my lord, so far as Part B of the demolition order is concerned, my lord, I have paid 1 crore 16 lakhs for retention, my lord. That has been paid. Corporation has given me receipt for that. So, my lord, if I have to file the appeal, my lord, I must have the certified copy, my lord. It's ready, my lord, but I cannot file it, my lord. If your lordship kindly takes up item number 81, it's, my lord, the similar matter can be disposed of, my lord.
So, of course,
I was praying for a direction upon the corporation. Let you please give me the certified copy.
Item 81.
And it's not that, my lord, that after the passing of the order dated 7th October, I have applied. In May also I had applied, my lord. That has, my lord, no certified copy has been given to me.
Yes, Mr. Das.
And part A and part B, both order has been challenged, both of the parties. And there is a provision.
My lord, with utmost of respect.
Just a minute, let him. Yes.
My lord, the second petition, my lord, 81, item 81, challenge the part A and part B. That is actually due to the lack of supply the certified copy. He cannot actually pay for appeal in the eye of law. And my lord, the petitioner have already challenged the order part B. Now,
So that's why he's not pressing for part B. He's only saying part A.
Sorry, my lord. Petitioner challenged the part A. And my lord, regarding that part A, that my lord, regarding this, that is the by the last occasion that order was passed and content application. My respectful submission before your lordship, the page 100, where he has been directed to actually prefer the that is content application disposed of. If your lordship kindly see page 100 and 101. My lord, without any, my lord, instruction, I am actually submitting actually from the petition. If your lordship kindly see.
Sorry?
Without actually receiving any instruction from the department, I am actually submitting before your lordships in accordance with the petition filed, both of them. My lord, my respectful submission is this, my lord, both are tried before the tribunal because 400, section 400, subsection 3 allowed both of them. I am supplied him the copy within certain days. That will actually.
You gave him a copy?
Lordship.
This is all I want, man.
Or your lordship say,
no, give him a copy.
Well, if your lordship kindly takes up page, my lord, 29 of my writ application, my lord. My lord, that is item number 81.
Okay,
they have received it on the same day, on 23rd of October, the day I, my lord, applied. My lord, the contents are very clear that now I need the original certified copy of the order with logo so that I can prefer an appeal before the appropriate forum, and I am ready to pay the necessary charges therefore.
This is the mode adopted, then no demolition orders will ever be
No, but look at this. This is also not fair.
20.
This is also not
1 year
fair.
has passed.
Look at this, the corporation.
1 year has passed.
Somebody has filed a writ petition for this. Take down in this item WPA 26690 of 2024. 81. Learned counsel for the petitioner, the present writ petition has been filed seeking a direction to the Calcutta Municipal Corporation to provide certified copy of the order dated 22nd March 2024 passed by the Special Officer Building in demolition case number 023-D-BR-12/2223 full stop, passed under section 400 subsection 3 of the Calcutta Municipal Corporation Act 1980 full stop. Learned counsel for the petitioner states that he had made a request to the Calcutta Municipal Corporation on 23/10/2024 to provide him with the copy of the demolition order which has been passed on 26/3/2024 full stop. Since then, he has made various rounds to the office of the Calcutta Municipal Corporation, but till date, the copy of the said demolition order has not been handed over to him. He further states that due to not having the certified copy of the said order, he has not been in a position to file an appeal before the building tribunal. He has not been able to prefer an appeal before the building tribunal. Full stop. This court directs the Calcutta Municipal Corporation to provide him a copy of the said order.
Certified copy with
A
logo.
certified copy
With logo, my lord.
of the said order with logo
Been told, my
within
lord,
a
that
period of
without
1
this,
week
the appeal cannot be filed.
from the date of communication of this order. Full stop. With the above direction, the present writ petition is
My lord,
disposed of.
my lord, one more indulgence,
My
my lord, I
writ
was
petition
seeking, my lord.
keeps my writ petition pending.
Just a minute. Yes, sir.
Yes.
Learned counsel for the respondent. The next one, petitioner has preferred the present writ petition being aggrieved by the inaction on the part of the respondent in not implementing the order dated 22/3/2024 passed by the Special Officer Building, whereby an order of self-demolition qua the unauthorized construction existing at premises number 764 Lashkar Hart Road, Kuber Residency, Calcutta. Full stop. It is a case of the petitioner that at the instance of the private respondents, illegal and unauthorized construction has taken place at the above mentioned premises. Full stop. Further, he states that illegal guest house is also being run from the said premises. Full stop. Aggrieved by the inaction of the respondent in not taking any action vis-a-vis the unauthorized construction, the petitioner had preferred writ petition number 20302 of 2021, and this court-wide order dated 18/2/2022 had directed the municipal respondent municipality to conduct a joint inspection and decide the matter accordingly. Full stop. After conducting the joint inspection and also after affording an opportunity of personal hearing to the parties, the respondent municipality had passed an order dated 22/3/2024 for demolition. Full stop. Petitioner contends that till date, the said unauthorized construction has not, till date, no action has been taken on the said demolition order. Full stop. Learned counsel for the respondent municipality seeks and is granted 4 weeks time to file his affidavit in opposition. Full stop. Reply to the same, if any, within 2 weeks thereafter. Full stop. In the meantime, learned counsel for the private respondent who has preferred a writ petition number so and so, wherein this court has directed the Calcutta Municipal Corporation to provide him a copy of the demolition, certified copy of the demolition order along with the seal of KMC shall prefer an appeal. States that he shall, after the receipt of the said order, he shall prefer an appeal. Full stop.
My lordship can give me a time frame, my lord. Within 10 days, my lord, I'll file the appeal. I shall file it, my lord, as early as possible, my lord. It's only for the sake of the certified
The
copy.
learned counsel for the respondent states that he will be preferring an appeal within a period of 4 days after receipt of the certified copy from the Calcutta Municipal Corporation. Full stop. He further seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. Full stop.
Grateful, my lord, the affidavit of service in item number 81, my lord, be kept with the record.
Affidavit of service in item 81 is taken on this.
I'm grateful to you, lordship.
List after, we'll have it, Mr. Karmakar. We'll have it after 8 weeks.
8 weeks.
After 10 weeks, there's no urgency here. After 10 weeks.
In the meantime, if they fail to prefer an appeal, I'll have a cause of action to come in application.
Yes.
My lord, I am for the petitioner, my lord, in item number 39.
For the HMC led by Ms. Sonal Sinha, your lordship.
But I am for respondent number 10.
Ma, there is an allegation of illegal construction, my lord, on part of the private respondent, my lord.
You are the private respondent. Wrong.
My lord, I have annexed, my lord, a copy of the annexed, my lord, a copy of the sanctioned building plan and, my lord, the photographs. Sanctioned building plan, my lord, clearly says, my lord, G+3. My lord, the photograph clearly depicts G+5. My lord, I made a representation, my lord. Let that be considered, my lord, by the corporation and consequential steps.
For the corporation.
Yes, lordship, I am for led by Ms. Sonal Sinha for HMC.
Mr.
Ms. Sonal Sinha. Your lordship, we have
Where
not
is Ms.
received
Sinha?
any instruction yet, your lordship.
What is the instruction?
We have not received any instruction yet, your lordship.
We decide the representation. Where is
As
Ms.
your
Sinha?
lordship, please, within a stipulated time.
Let that be considered.
What do you have to say?
Let that be considered, my lord. Let that,
Representation. You are happy with that?
my lord.
You are happy?
I'm happy that I am appearing before your lordship, my lord. With that only I am happy.
All right.
Submit the report, one page.
Report of
State.
What is the report? You tell me.
Matter, issue has been taken with the corporation itself. Only that is
report.
State on the petition, the present writ petition is alleging illegal construction carried out on behalf of respondent number 10 at 144/31 Dharamtala Road, Havra. Full stop. It is the case of the petitioner that he is the owner and resident of premises number 144/31 Dharamtala 30. No, what is it? 31 or 33?
He is in 33,
33,
construction in 31.
33.
But only that I have denied. Only report that I have
My
denied.
lord, paragraph number 5, my lord, I have stated, my lord, construction is at, my lord, 144/31 Dharamtala Road.
Resident of 144/33 Dharamtala Road, Havra. Full stop. The private respondent obtained building sanction for construction of G+3 storied building in the neighboring plot premises number 144/31. Full stop. 144 Dharamtala, Havra. Sorry, 144/331 Dharamtala, Havra. Full stop. However, the private respondent constructed G+5 story. Full stop. The petitioner preferred a representation dated 1/8.
1st of August. 1st of August 2024.
Qua the said unauthorized construction. However, till date, no action has been taken. Full stop. Learned counsel for the respondent municipality appears and submits that they are ready and willing to consider petitioner's representation dated 1/8/2024 Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the statement made by the parties, this court directs the petitioner respondent municipality to decide petitioner's representation dated 1/8/2024 within a period of
Your Lordship, 8 weeks.
within a period of 8 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as the private respondents by way of a speaking order. With the above direction, the present writ petition is disposed of.
Deeply obvious.
Report of the state is taken on.
Much obliged, my lord.
Grateful.
Your Lordship, as the affidavit is not called for, Your Lordship, kind.
So that line will come.
Is it responded
No
for?
affidavit is called for. All right. Rest of the matters tomorrow.
My lord, 40 to 41, well, similar matter, it will take 1 minute time, all the, my lord, respondents are present, my lord. Just, my lord, similar order we passed, my lord.
What's
Kind
the
similar-
order?
This is my affidavit, 40, 41.
What are you asking?
My lord, only to consider my representation in the light of the order passed by the
That Sahika and.
Sahika.
Oh, no, we'll have it later. No, this is not that simple. That
My lord,
this
lordship,
representation is a problem.
my lord, lordship, kindly see the similar orders, my lord, passed by the coordinate bench of this court, my lord, passed by the Honorable Justice Harish Tandon and Honorable Justice Somapti Chatterjee.
No, these are
Sampa
orders which
Sarkar,
are
my lord.
passed. We don't even know whether these posts exist, don't exist, Mr. Chakravarti.
My lord, I am appearing for the municipality.
Yes.
My instructions are that there are vacancies available within
You'll
the
consider.
My lord,
You'll consider the
yes, my lord, because
representation.
in the previous writ petitions as well, the DLB has been instructed to consider and they have granted approval.
Matters, my lord, DLB, my lord, accord approval, my lord, in all the
All right,
matters.
give it.
Lordship, kindly. This is my affidavit, sir. 40. The affidavit, sir. My lord, last order, lordship, kindly see the, my lord, passed by my lord Justice Kaushik Chandra, my lord,
Show the order.
page 59, my lord. Page 59.
And one of the approvals, my lord, is at page 70 by the director. Page 70.
My lord, I have annexed
Approval means somebody
Approval,
else.
Director of
approval
local
by the
bodies.
director of local bodies.
Yes, page 59.
page, my lord, page 59,
Yes.
the order passed by my lord Justice Kaushik Chandra, my lord.
Director of local bodies, you appear for director of local bodies.
Yes, state is appearing.
I have no instruction.
You have?
I have not received any instruction.
My lord, lordship, and lordship kindly see, my lord, this order was passed, my lord, 1st October 2024, and this is the also the another approval of in another matter, my lord.
The petitioner has preferred the present writ petition seeking a direction against respondent number 2 and 4 to engage the petitioner in the post of Sahika at Suripara, Fulbari, Shishu, Shiksha Kendra or any other adjacent ward wherever the vacancy is available. Full stop.
My lord, subject to correction, my lord, the appointment will be recommended by the municipality by 5 and 6, my lord. 4, 5 and 6. They are the concerned authorities and thereafter it will be approved by the DLB.
So then we'll say seeking a direction against the respondents.
Yes.
Responding.
I will not specify then.
Respondent
Against the respondent municipality.
Right, sir. Respondent municipality will grant approval.
No. My lord, DLB will
DLB will the consent against the respondent.
in all matters, my lord, DLB accord the approval.
Against who? DLB is party number?
Yes,
Respond
party
number?
number 2 most of. Respond number 2.
Respond number
2.
2. Respond number 2. Full stop. It is the case of the petitioner that she was appointed. She was engaged as a contractual Sahika at Suripara, Fulbari, Shishu, Shiksha Kendra for more than 7 years from the year 2000 8 to 14, full stop. Thereafter, her engagement was not, her contract was not renewed on the ground that she had attained. She had attained, what is the age?
She was underage, my lord. Underage, my lord.
She was
Underage.
She was underage.
Now he has, my lord, fulfilled all the eligibility criteria.
She was underage and she was underage, full stop. Learned counsel petitioner states that now she is 49 years old. Petitioner states that her client is 49 years old and is eligible according to the guideline dated 30th May 2000, full stop. The respondent municipality has notified 10 vacant posts for the 10 vacant posts for Sahika
Page 70.
to be filled by the eligible candidates, full stop. It is the contention of the petitioner that similarly situated persons under the jurisdiction of Durgapur Municipal Corporation, Asansol Municipal Corporation, Old Municipality filed various writ petitions before this court, and all of them have been re-engaged by the said municipalities. In view of the same, the petitioner is seeking a direction for her re-engagement to the said post of Sahika afresh in terms of the above mentioned guidelines, since she is eligible for the said appointment, full stop. The petitioner had submitted a representation dated 4/9/2024 claiming re-engagement. However, no action has been taken on the said representation, full stop. Learned counsel for the respondent corporation submits that the authorities are ready and willing to consider and decide petitioner's representation in a time-bound manner. Who will decide the representation?
Lord, DLB, my lord. I made a
फिर वो छोड़ दो.
page 72, my lord, my representation.
फिर ऐसे कर लो. This court.
72 is Malda, chairman. No, copy forwarded to the director of local bodies. Oh, next.
This court observes that various orders have been passed by different coordinate benches of this court, directing the relevant authority to consider the case of re-engagement on the post of Shishu Shiksha Sahika, full stop. The director of local body is therefore, directed to consider the re-engagement of the petitioner in accordance with law and in the light of the observations recorded herein, and also in terms of the guidelines dated 30th of May 2000, especially clause 7 bracket may KA, within 1 month from the date of communication of this order, and communicate the decision to the petitioner, full stop. This court has not entered into the merits of the claim of the petitioner. Accordingly, writ petition so and so is disposed of. और वो line लिख देना. No, nothing is admitted. No affidavit is called for. ठीक है. Anything else?
Yes, no.
That's it.
Nothing. My lord, next matter is also the same. Only the, my lord, age and school is different. Otherwise, my lord, same, similar. Against the same municipality, same.
Age and school.
Age and school is different. দিয়ে দিচ্ছি সব নামগুলো দিয়ে দিচ্ছি। My lord, affidavit of service be kept on record. My lord, 40, 41, 42.
All right.
Grateful.
Third also age and
42, I am for the state respondents, my lord. These are the affidavit.
My lord, the item number 27, my lord. In the item date of demolition, if he fixed it after day after tomorrow, my lord, can it be taken at a earlier top tomorrow, my lord? It is made not today, my lord. On behalf of
coming tomorrow only. Item 27 is tomorrow only. Not today. That tomorrow it will come up.
My lord, with dire urgency.
Can be taken at
My lord, with dire urgency, I'm mentioning this.
already.
What are you mentioning at this time?
I know my lord doesn't allow. My lord, it is item number 47 of your list. I'm kindly just praying for upgradation because it is under dire urgency I'm mentioning the matter because it is about the illegal construction, but the private respondent has been
Illegal construction, all will be demolished in accordance with law.
I am the
Very good.
petitioner. I won't. I'm for the one who has been struggling it. I haven't built the illegal construction. I'm against it. I have filed
Very
the
good, you are against it. We are also against all illegal
Yes.
construction. It will be
The-
demolished in accordance with law. So
Yes.
there is no urgency. Let
Your
it
Honor,
come up.
my
Let
lord,
more floors be added. Then we'll get it entire.
my lord,
building
it has already
demolished.
finished. He started another building. That's
All
why.
right, sir, let him construct 3 more. It will all be demolished in accordance with.
Yes, but the private respondent, my lord, has been doing false FIRs on me, and the police has been harassing me.
That
That's
is
why.
your separate problem. We are only concerned with unauthorized.
I'm just saying, if you could be tomorrow, at
You
least
see
with
that
the-
no urgency.
Representation will consider within a period of time.
We have given 1 month. 1 month.
Yes.
my lord.